Are you looking to change your mood? Well, these are full spectrum infused gummies from Hello Mood. I've been trying mood products for about a month now, and all I can say is wow.
morning, everyone. Please be seated. We are on the record in the Iowa District Court for Jefferson County. We are here on case FECR 005143. It's captioned the State of Iowa versus Willard Chaiden Miller. Present for today's sentencing hearing is the defendant, Mr. Miller, along with his attorneys, Christine Branstad and Nathan Olson. The state of Iowa is represented by Jefferson County Attorney Chauncey Molding and Assistant Iowa Attorney General Scott Brown. The record in this case shows that on the 18th day of April, the defendant entered a plea. Mr. Miller entered pleas to the crime of murder in the first degree, which is a Class A felony pursuant to Iowa Code Section 707.1 and 707.21a. And that based on the fact that Mr. Miller was a juvenile at the time that this crime he committed, he was a juvenile, the parties agreed in the court order that a pre-sentence investigation be prepared and submitted to the parties and to the court. Mr. Molding or Mr. Brown, has the state received a copy of the PSI?
We have, Your Honor.
And do you have any additions, corrections, deletions, or objections to its use?
No, Your Honor.
Ms. Branstad, regarding the pre-sentence investigation, what record would you like to make?
Your Honor, we have no objection to the use of the PSI. With regard to corrections, I believe that sentencing memo has now been filed, and that sets out a number of minor corrections, ranging from, I think that within the PSI gives my client's height at arrest, which was 5'6", he's now 6'4", to some corrections as to my client's perception of some minor notes within the PSI. None of those should interfere with this court's ability to use the PSI and to rely on the PSI for sentencing.
And did the state receive a copy of the sentencing memo?
Judge, there's been a reference to the sentencing memo here on the record, as well as prior to coming in here this morning a few minutes ago. I do not have a copy of that yet. I'm not sure when it was filed, but I don't see any reason why we can't proceed regardless.
I just printed off a paper copy for counsel and myself. I don't know so I'll give you guys, everybody has a copy of it.
And Your Honor, I did just hand my computer to Mr. Molding to review those corrections, and he had an opportunity to look through those.
We'll wait for Carrie to get back with those memos. counsel, do either of you or any of you know of any reason why judgment and sentence should not be pronounced today against Mr. Miller?
No, Your Honor.
No, Your Honor.
And Mr. Miller, do you know of any legal reason why I shouldn't sentence you today?
No, Your Honor.
With regard to the sentencing hearing, I'll allow the state to put on its evidence and argument first. Then the defense will have an opportunity to do the same. Mr. Miller will have an opportunity if he wishes to make a statement before sentencing, but it's not a requirement. And then we'll have any victim impact statements read after all those things occur. But we'll start with the state, and is there any evidence you'd like to offer this time, counsel?
There is, Judge. If I could just briefly outline that for the court so you kind of know what you're in for, if that's okay.
Go ahead.
So it's our intention in our presentation to offer 4 witnesses. Trent Willard, who is the DCI agent, who is the assigned case agent for the investigation of the death of Nohema Graber. He will testify to kind of give the court and everyone an overview of the investigation and the evidence that was collected by law enforcement. Secondly, we're going to call DCI Special Agent Ryan Kedley, who will provide a summary of the interviews of both the defendant, Willard Miller, as well as the co-defendant, Jeremy Goodale. We do have some excerpts from those interviews that we will play for the court. Total minutes on the excerpts was right around 50 minutes, I believe. Thirdly, we're going to call Fairfield Police Officer Julie Kinsella, who was the lead officer and detective that assisted with the investigation into the death of Nohema Graber. And then lastly, we're going to call Mike Heinricy, Heinricy, who is the warden of Iowa Medical and Classification Center at Oakdale, which is the reception center the court is aware for all prisoners. He also was one of the persons that spearheaded the youthful offender program at Oakdale, because it is our understanding that whenever the defendant goes to prison, he will initially be in that program. So I think he has some relevant information to offer, not only initially with the youthful offender program, but then what may be in store for the defendant, depending on his length of sentence that the court imposes on him. So that's our presentation of our evidence. We also have, one other thing that I might mention, as the court is aware, under these circumstances, and since the defendant was under the age of 18, whenever he committed the crime that he's pled guilty to, Iowa Code Section 902.1, Sub 2B, 2A, provides a number of factors for the court to consider in fashioning an appropriate sentence. I won't go through all those factors for the court. I know that you're well aware of those. But all of our evidence that we have today will impact one or more of those factors that the court has to consider in fashioning the sentence for the defendant. We are going to be recommending at the close of all the evidence today, whenever we do make our sentencing recommendation, that the defendant, Willard Miller, be sentenced to a term of life with the possibility of parole, and that he be made to serve a 30-year minimum sentence before he is eligible for parole. That was our agreement with the defense. Of course, they can make any recommendation that is legally available to them, but that's what the state will be recommending in this case. And lastly, before I call any of our witnesses, Judge, we do have a number of exhibits that we are going to be offering for the record here. We have numbered them 100 through 133. Inclusive of all those numbers, we have provided an exhibit list to the court which details what those exhibits are, describes them for the court. We would offer those collectively at this time, exhibits 100 through 133. There are several photos in that on that exhibit list that show Nohema Graber the railroad tracks where she was found, they're not pleasant pictures to look at. I know some of the family here has been notified of that. I'm not sure all of them have. So by way of this statement, we're letting them know that, and those pictures are 123, 124, 125, and 126. So there are 4, I believe. So just by way of noting those for the record, so we would offer those exhibits at this time, and then we would be prepared to call our first witness. Thank you.
Regarding the exhibits offered by the state.
Your Honor, we do object to exactly the photos just referenced by the state. That's 123 through 126. Your Honor, those are not probative on any issue of sentencing. I understand that the state's argument is that those would go to the nature of the crime, but the photos don't depict anything not within the autopsy report, not within testimony, and in this case are unfairly prejudicial. If the court accepts the photos, we would ask that the court limit publication of those within this courtroom. Certainly there is nothing that must be publicly viewed in order for the court to make whatever consideration the court makes, and charging the situation even more within the courtroom does present a danger of unfair prejudice.
Mr. Brown, you would offer state exhibits 100 through 126 at this time?
Correct. Judge, if I may, just for the record,
Go ahead.
part of the factors under the code section, may I remain seated? I don't mean to be disrespectful. Okay. The factors under 902.1 that the photos that we're offering goes to would be the severity of the offense, the nature of the offense, the heinous, brutal, cruel manner of the murder, and if I didn't mention severity of the offense, it goes to that factor as well. So it impacts several factors under 902.1. I would tell the court that there are a number of pictures that we have. We have limited this to 4 photos. We're also offering the autopsy report as part of our exhibit list. But all of those things, I know they're not pleasant to look at. I understand that. But that should not keep them from the court's consideration or from the public's view, since this is a public hearing. So we would resist the defendant's objection on those grounds as well.
Any further record we need to make on those exhibits?
Your Honor, I understand that the rules of evidence are not the same within a sentencing procedure, but the constitutional protections are still applying. I think that's within Gideon versus Wainwright. And Your Honor, creating that, publishing those photos does not serve any significant aspect of sentencing, even within showing the severity of the crime. The photos don't depict anything that really shows much about the crime. They're just very sad photos, and it creates the danger, again, of creating an emotional charge within the courtroom.
Over the objection of defense, I'll admit state's exhibits 123 through 126, and I'll admit 100 through 122 without objection. Did the state have any objection to the defense's exhibits?
No, we were provided a fairly comprehensive list of the exhibits they had. I don't believe we had any objection to any of them. Judge, I want to make sure we're clear on numbers.
Your Honor, you admitted all the exhibits up to 126. The state has also offered 127 through 133, which are the autopsy report and video records, as well as some evidence from the defendant's cell phone and some transcripts.
And the defendant's position on the admission of those exhibits.
One moment. Your Honor, we don't object to admission. Certainly there's argument to be made as to the weight to be given by the court. This is an unsworn statement, and the speaker is not available for cross-examination. I think without the ability to confront that statement, minimal weight should be given, but we don't object to its admission.
One moment, Your Honor, I'm sorry.
And Your Honor, that's to both 129 and 123, which are essentially the same thing as the video and the transcript.
I see 127. I don't see 129. Is there a 129, Mr. Moore?
There is, Your Honor. 129 is a video interview with defendant Jeremy Goodale.
Okay.
Judge, obviously the videos we can't upload, that may be what you're looking at. We have those on a flash drive here for the court, so both interviews in their entirety.
Is it the same videos offered during the suppression hearing?
The Miller interview would be the same one, but the interview of Goodale I don't believe has ever been offered in a hearing, not to my recollection. He had proffered with the state in February of this year. That's that interview. It's a little over 2 hours in length.
Well, I will admit states 127, 130, 131, 132, and 133. And I'll admit exhibit 129. Is there a 128?
128 is the video interview of the defendant, Miller.
Okay,
Yeah.
so I've already watched that, but I will admit that as well and give it the weight I believe it deserves. Regarding the defense exhibits, I believe it's MM through, MMM, triple M through triple Z, and then quadruple A through quadruple C. Any objection to those exhibits from the state?
Your Honor, may I be heard? We have not offered those yet, and I'd like to wait until our evidence begins. We may limit some of those.
Okay. Is the state ready to proceed with sentencing?
We are, Judge.
Okay, go ahead.
Our first witness is Agent Trent Belden.
You promise to affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat. There's a button at the bottom of that microphone. Thank you.
Good morning.
Good morning.
Can you please state your name for the record?
My name is Trent Villeta. It's V as in Victor, I-L-E-T-A.
And how are you employed?
I'm a special agent with the Iowa Division of Criminal Investigation
And how long have you been employed in that capacity?
since 2006.
All right. And where is your current assignment?
I work for the Major Crimes Unit based out of Cedar Rapids.
Okay. Can you describe for the record what the Major Crimes Unit, what their function is?
Sure. It's the Major Crimes Unit is essentially a violent crimes unit. We are an assist agency, so we offer expertise in death cases, officer-involved shootings, other violent crimes that maybe smaller departments won't have. And so when something like a murder happens in a smaller community, we will work with that department during that investigation.
Over the years, do you know how many death investigations you've worked?
I've been asked that quite a few times. I'm not sure, a lot.
So in this particular case involving Nohema Graber, were you assigned to work the disappearance and ultimately the death investigation involving her?
Yes, I was.
And when did you get that call?
We got that call on November 3rd in the evening, approximately 8:30 or so.
Can you just describe for the court how that process occurs?
Sure. When, as a request agency, we have to be requested by a police department, a sheriff's office, county attorney's office. So my supervisor at the time received a call from the Fairfield Police Department regarding a missing person. As I was coming down towards Fairfield, I was notified that the missing person's body was located.
And who was that?
It was Nohema Graber.
So about what time did you arrive here in Fairfield?
It was sometime between 9:30 and 10 p.m. on November 3rd.
And can you generally describe for the court how it was that Nohema Graber had been located by local law enforcement?
Sure. The Fairfield Police Department took the initial missing persons report. They conducted a very thorough investigation as far as the missing persons investigation goes. They had worked, I think, pretty much maybe 12 to 15 hours so far. During their investigation, it was determined that every day at 4 p.m., Nohema Graber would go to Chautauqua Park and do 3 laps at the park. So they were able to determine that she was last seen at 4 p.m. on the 2nd, leaving the school, and it was a logical next step for them to search the park.
And was there a vehicle that was associated with Nohema Graber?
She had always drove a van, and that van was seen entering the park around 4 p.m. on November 2nd.
And you didn't mention that there was surveillance video checked at the school to determine the exact time that she left on November 2nd.
That is correct. There was video of her leaving shortly before 4 on November 2nd.
All right. Now, the report of Nohema Graber's disappearance did not come in until the following day on November 3rd. Is that right?
That's correct.
Can you just generally describe for the court what the circumstances of that particular notification were?
Her husband, Paul Graber, had come to the Fairfield Police Department, I believe around 8 in the morning after Nohema did not return home on the 2nd.
Had Paul Graber been out of town on November 2nd as well?
That is correct.
And did they live in the same house together here in Fairfield?
They did.
Did anybody else live with them?
They have a son that lives with them.
Had you or other law enforcement prior to Nohema Graber's prior to her being found, had anyone contacted the school to see if she had arrived for work on November 3rd or had been seen by anyone at the school?
Yeah. Yes, like I said, the Fairfield Police Department conducted a very thorough investigation, and part of that would be to contact their Nohema Graber's employer.
So tell us, Agent Willard, at the time that you arrived here on November 3rd in the evening, what was the status of the investigation at that point, given that Nohema Graber had been located?
So most of these investigations, they're unpredictable. You're not quite sure what you're stepping into. The initial investigation, as far as the missing persons investigation, was done very well. We had located Nohema Graber, or the police department had located Nohema Graber. So we knew she was deceased. It was definitely suspicious that when I had walked into the Fairfield Police Department, there was a whiteboard where the Fairfield Police Department had collected statements that they had heard regarding possible suspects in the death of Nohema Graber.
So whenever you mentioned that it was a suspicious death, what was that based upon?
It was based on how her body was located. She was in the woods. She was covered in a tarp with a wheelbarrow over the top of it and then a railroad tie on top of the wheelbarrow. All that would obviously indicate that Nohema Graber was not able to do that herself. Someone else would have had to conceal her body.
So at the time that you arrived at the Fairfield Police Department, was there one in particular person that was present that ultimately provided you critical information in determining who was responsible for Nohema Graber's death?
So, yes, when we got there, it was very fluid. There was a lot of information coming in. This wasn't an apartment we work with very often, so after we kind of got settled, it was determined that about an hour earlier, John Burnett had come to the police department with information as to possibly who killed Nohema Graber.
And what was John Burnett's relationship to either the defendant in this case or Jeremy Goodale?
He was very good friends with both of them, probably a little closer to Jeremy Goodale, but he would have been in that friend group.
All right, we'll get to John Burnett's information here in just a second, but I want to talk to you a bit about location where Nohema Graber was and some other information that relates to the crime scene. Did you go out to Chautauqua Park?
I did.
All right, and well, let's back up just a second. Were you at some point provided a photo of what Nohema Graber looked like prior to death?
Yes.
All right, I'm going to show you what's. We can put that up. What? I can't hear you. On the screen it states Exhibit 100. Do you see that?
Yes, I do.
And what is that a photo of?
That's a picture of Nohema Graber.
It's one of her school photos, possibly, or family picture?
I always thought it was her school photo.
Okay. This shows her in 2014-15, is that right?
That's correct.
Okay. All right, let's talk a bit about the area. Agent Valletta, States Exhibit 101. Can you see that photo?
Yes, I can.
Or this diagram?
Yes.
So on here is this loop with a red, it says Chautauqua Park, is that correct?
That's correct.
What does that loop represent?
That's the walking path around the park.
Okay. And then the highway that is at the bottom of the diagram, is that one of the main highways through Fairfield?
Yes, that's the coming off Highway 34. I think that's Business 34. So that'll bring you right into Fairfield.
Okay. And you have been to this location, is that right?
That's correct.
On here is access, an indication of access to the railroad tracks. Do you see that?
Yes.
What does that represent here on this particular exhibit?
Yeah, the access to the railroad tracks is actually a path. It's like, I don't know, I would call it like a truck path for maybe the railroad to do maintenance. So it's wide enough for a car to drive back to the railroad tracks.
And there's also an arrow here near the railroad tracks that indicates body location. What does that represent?
Yeah, that's where Nohema Graber was found. There's a bridge there over the railroad tracks. Below the bridge is a stream. Nohema Graber would have been located maybe 10 meters or so down from the railroad tracks. So it's a very steep incline and it's very wooded. So that's where the body was.
States Exhibit 102. Did you ever go to the Miller or Goodale residence in Fairfield?
I was at the Miller residence.
Okay. Okay. And you're familiar with the location of the Goodale residence, I assume?
That's correct.
That's what is that what this particular exhibit shows, the location of both of those homes?
That is correct, yes.
Who lived at the Miller residence other than the defendant?
His mother and I, those were the only two that I was aware of that lived there.
And Goodale, do you know who lived at his residence other than Jeremy Goodale?
I think it was his father. I don't think his mother was around, but I'm not quite sure on that.
And we've got a pointer up on the map now. Is this the area that we were just looking at in the previous exhibit that is Chautauqua Park?
Yes, that's Chautauqua Park.
Do you know roughly what the distance is to either of those residences to Chautauqua Park?
I would describe it as walking distance, a little over a mile, I think.
Okay. State's Exhibit 103, do you see that?
Yes.
During the investigation, was the vehicle driven by Nohema Graber located?
Yes, it was. It was located, as you see that arrow down at the bottom of the picture. That's at the end of Middle Glasgow Road, which is a dead end. And at that end of the road, there's some trees and a path for, I think kids would go back there and mess around. So it was a well-known road, especially to the police department.
Okay. How was it that law enforcement was able to locate Nohema Graber's vehicle?
With some of the information that we were able to get from John Burnett was that the vehicle was located at a dead-end road. Lieutenant Kinsella of the police department knew or had a very good idea what road they were describing, and she was the one that found the vehicle.
Right, and up here in the upper left-hand corner, that is Chautauqua Park that we were looking at in earlier exhibits, is that right?
That's correct, yes.
And what would be roughly the distance between the park and the location of the vehicle?
Like for driving, it's just a few minutes away.
At the search was done, well, let me back up. Did you learn the specific nature of the injuries inflicted upon Nohema Graber?
Well, initially at the scene, I had did a brief examination of the body. Part of the case agent's responsibility is to assess what kind of additional resources are needed. That usually entails us going to the scene. Well, it doesn't usually. We always go to the scene to make that determination. I needed to observe her body just to brief our crime scene team on kind of what they were getting into when they got there. My initial impression is there was a severe head trauma. I did not observe any other injuries.
Are you familiar with the term blunt force injury?
Yes.
Is that what it appeared Nohema Graber had suffered, was a blunt force injury?
That was my initial impression, yes.
And as a homicide detective, what exactly does that mean to you?
Blunt force traumas, it can mean anything as far as, in this case it was a baseball bat, it could be a hammer, anything that would be able to hit you hard enough to cause injury.
And during the search of Miller's residence, was any item found that would be consistent with an item that could cause blunt force injury?
Yes, there was a baseball bat located in the Miller residence.
And this is that State's Exhibit 104, is that correct?
That is correct.
Where was this exactly in the Miller residence?
It was in Willard Miller's room behind a chair.
So this obviously photo was taken with the chair removed, is that right?
Correct, yes.
And so just to fast forward a bit, Jeremy Goodale was interviewed in this case, is that right?
That's correct.
Did he provide an explanation in his interview that would be consistent with the description of this bat as being used to cause the death of Nohema Graber?
Yes, he described the bat that was used as having like flames or something on that, as you can see in the photo, that would coincide with what we're looking at in the photo.
This bat would have been submitted to the DCI Crime Laboratory for DNA analysis, is that right?
That's correct.
Did anything come back positive that would have identified it as being directly associated with the death of Nohema Graber.
No, I think it was speculated that it was cleaned pretty well.
So let me just ask you that, in your experience as a law enforcement officer, can DNA be destroyed?
Very easily, yes.
It could be wiped down or cleaned. That would remove any trace of it. Is that right?
That's correct, yes.
Let's move to the location of the van that we've seen earlier in the overview of the map. This is State's Exhibit 105. Do we see the vehicle here in this picture?
Yeah, so right where the red dot is, you look above there, that's the license plate of the van. This picture also depicts, it was supposed to depict the tire marks in that grass going back. So you can tell that there was effort made to conceal the van.
And State's Exhibit 106 shows the van as well. Is that right?
That is correct, yes.
And whenever you talked about the attempt to conceal it, was it basically parked back into some trees and bushes? Is that correct?
That's correct.
And this would have been off the road. How far, if you know?
It's not too far off the road. It's interesting because it's a long dead-end road. The next closest house will be roughly maybe a quarter mile away. So they're limiting the exposure to traffic because of the dead-end road. But again, it's kind of an area that people go to.
While we're talking about the location of the van and where it was located off Old Glasgow Road, did you or other officers in the investigation develop information that both Miller and Goodale had been picked up on November 2nd by another person?
Yeah, yes, we did.
Okay, was that person's name Habib Sain?
Yes, it was.
And can you describe to the court what Mr. Sain informed law enforcement of?
Yes, he told law enforcement that approximately 4:50 or so p.m. on November 2nd, he was contacted by Jeremy Goodale and asked for them to be picked up on Middle Glasgow Road. We were able then to find camera footage which corroborated what Mr. Sain said. It shows two males walking down the road and then Mr. Sain's car coming into a driveway to pick them up.
And is the person that provided the surveillance video, is his name Ryan Ford?
Yes.
He just happened to live near the area?
Yes, he would be the house that would be closest to the van.
And just to make sure we're clear, Habib Sain was not involved in the death or disappearance of Nohema Graber, is that correct?
We developed no information that would show that he had any involvement whatsoever.
He just happened to be friends with both Miller and Goodale?
But yes.
All right, let's move to the photos from Chautauqua Park. State's Exhibit 107, what does that show us here?
So that's going to be a path that will lead you, you're actually inside the park here. As you travel down towards the police vehicle, you'd be traveling towards the walking path.
This would have been the walking path that you and other officers would have been told that Nohema Graber would take daily.
Yes.
It's essentially a big loop around the park, is that right?
Yeah, yes it is.
And this State's Exhibit 107 just shows a portion of that, is that right?
Yeah, that would be the most likely entrance for her to enter onto the walking path.
Let's move down the path a bit. This is State's Exhibit 108. This is more towards that police vehicle that we just saw in 107, is that right?
Yes, sir.
All right, this area here that has yellow tape, can you tell us what that represents?
Okay, so now that would be, as I described earlier, the truck path that would lead you up to the railroad. Right to the right of the far right of this picture, kind of below the crime scene tape, is where we believe that the assault occurred.
Was there evidence that an assault had occurred in that area?
Yeah, there was quite a bit of blood, kind of starting around that area and then along the path up to the railroad tracks.
And we can see the railroad tracks in this photo in the distance, is that right, where the pointer is?
Yes, those are the railroad tracks.
And this is a what is that, like a dirt pathway, is that correct?
Yes, that would just be for a vehicle just to pull off. And then, like I said, probably, I'm guessing it was maintenance vehicles that would go back there.
And the main path here is actually paved with asphalt, is that right?
Yes.
Okay, State's Exhibit 109, does that show the same area, just a little bit more to the, what would that be, to the east?
I believe that would be to the east, and yes, that's, so now we're just looking more to the right of that last photograph. Again, probably at that curve area was most likely a spot for the assault.
And whenever you received the information from Jeremy Goodale, did that match up with some of the things that we're seeing here in these photos?
Yes, it did.
As far as the physical locations, what I mean?
Yes.
State's Exhibit 110, is that just the opposite direction that we've been seeing in the other two photos?
Yeah, so this is essentially looking at, you're standing at the crime scene tape looking up the hill.
And State's Exhibit 111?
That appears to be more, I believe that's going further east, and then you're looking more towards the path again.
We can see the crime scene tape, I think, vaguely here in this photo, is that right?
That's correct, yes.
State's Exhibit 112, again, shows the crime scene tape, is that right?
That's correct,
And
yes.
this is the same area?
Yes.
And is this where law enforcement made the determination that, based upon the information that you had, that Nohema Graber was attacked?
Yes, our determination kind of corroborated, then it kind of, our information was corroborated by Jeremy Goodale, as that being the location where the assault took
And there was also physical evidence, which I think you mentioned earlier, that was present in this general area that would have suggested that.
So there was, yes, there was quite a bit of blood there. As we move through these pictures, there's probably 3 separate times where it looked like Nohema Graber's body had stopped moving, where blood had collected.
State's Exhibit 113, where are we now moving towards the railroad tracks?
Yes, so now we're more on to the path heading up towards the railroad tracks.
And this is the crime scene tape here that we've used as a reference point on our photos, is that right?
That's right.
Exhibit 114, are we now beyond the crime scene tape, more towards the railroad tracks?
Yes, so that again, that's depicting the truck path or vehicle path.
In this area,
Turn
go ahead,
right,
sorry,
you'd
go
be
ahead.
heading towards the body. Sorry.
And in this area here, would there have been was there other evidence of blood that was in the grass?
Yes, right around that, at the, right past that curve, we would see then another significant amount of blood, which would suggest that the body had rested there for a bit.
And Exhibit 115 is the opposite direction from the previous photo, is that right?
That's correct.
This gives us a little bit different perspective from the path, or back towards the path, would that be true?
It's essentially looking at the bottom of the railroad tracks towards the path, yes.
State's Exhibit 116, what does that show us?
So again, this would be the path at the far left along the railroad tracks would be where the bridge is. And then the path itself will end essentially where, above where Nohema Graber's body was located.
This would be towards where her body would have eventually been located, is that right?
That's right.
And State's Exhibit 117, is that just the opposite direction of the previous photo?
Yes, that's just a perspective of looking, the switching ends essentially.
State's Exhibit 118, what does that show us?
So now we're on top of the railroad tracks. Again, we find some blood along there, not as much. But you'll see then, of course, the bridge going along there. So we're moving towards where her body was located.
Is this the bridge that you referenced? Is that the area I have the pointer on now?
Yes, it is.
And would it have been in this general area where the pointer is as to where Nohema Graber would have been eventually located?
Yes.
State's Exhibit 119, what does this show?
So it's a little hard to see from a distance, but right where that pointer is, you'll see a bit of red. That would be the wheelbarrow. So that's where her body is located.
Can you describe for the court what the importance was of the wheelbarrow as it relates to where she was found and how it may have been utilized?
So the investigation showed several different times that a wheelbarrow was used to essentially transport the body of Nohema Graber. It appeared that they didn't calculate weight and what the wheelbarrow could hold, so the wheelbarrow essentially broke apart, which is, I could only speculate that's why it was left there. It would not have been easy to carry out, but it was part of the plan to move her in that wheelbarrow.
State's Exhibit 120, does that show that area that we just saw here in 119? You can see faint red in this picture. Is this a bit closer?
Right, so that would be then the railroad tie on top of the wheelbarrow.
Is this where the pointer is? What is that?
That's the railroad tie.
And then the red that we see in this photo, both above the tie and below, is what?
That's the red wheelbarrow.
Standing in this position, would you know that a person is under that wheelbarrow or railroad tie?
You cannot see her from there.
State's Exhibit 121, what are we seeing in this photo?
So these are then would be the three items that were used to conceal a body. So you would have the railroad tie up above, the wheelbarrow right below that, and then her body is actually located. It's wrapped in that gray tarp right to the left of the wheelbarrow where the red pointer is.
And were you at this scene before Nohema Graber was recovered?
Yes.
Okay, before anything had been disturbed with regard to the wheelbarrow or the tarp or her body, is that right?
That is right.
Whenever you were right next to it, could you see that a person was actually wrapped up in the tarp?
When you were right next to, you could see a shoe and I think a hand underneath, kind of popping out underneath.
Okay. Just by way of warning for those in the courtroom, the next two photos may be difficult to look at for some people.
Your Honor, and I renew my objection to publication of those photos. I believe that the court witness can look at them without publishing them to the courtroom.
Overruled, Mr. Brown. You can
Okay, the next photo. Next photo is Exhibit 122, which shows a little bit closer area of 121. You see that?
Yes. So again, that would be your tarp. Now that you know that there's a body under there, you can kind of as you look closer, you can kind of see where she would be located again, where the red pointer is. And like I said, there was just a couple small pieces or bits of body part that we could see at that time. So I had to make the determination to lift the tarp to get a closer look at her.
So when Nohema Graber's head had been under the area where we see the area here where the red wheelbarrow is,
Yes.
and then what appears to me to be jeans or some sort of pants, that's what it's shown here on the pointer. Would that be true?
Yes.
Okay. Was the wheelbarrow removed
Yes.
before you opened the tarp?
Yes.
Okay, that's what the next photo shows. Is that what we see here?
Yes.
So the wheelbarrow's now been removed?
Yeah, you can see it kind of at the bottom right corner.
Right down here?
Sure. Yes.
Okay. And then this area to the right-hand corner of the photo is what?
That's the where the pointer is right now. That's a railroad tie, and then that's how her body that was wrapped in the tarp.
So did you or members of the crime scene team then unwrap the tarp?
So yes, the crime scene team was there. I was there with a couple other people, and so we unwrapped the tarp so they could photograph it while we were doing that.
And whenever you unwrapped the tarp, Nohema Graber was there, correct?
Correct.
Was she dressed?
Partially.
Can you describe that, please?
She was just wearing a bra. Her pants were kind of down around her ankles. It was pretty easy. When we were standing there, we started looking around. We could see that, like, I think she had a turtleneck sweater was up in the trees, had been thrown up in the trees, and another shirt had been thrown up in the trees. They weren't well hidden, but she was partially nude when we recovered her.
Exhibit 124 shows the body of Nohema Graber head to toe. Is that correct?
Yes.
It's coming up here. I just want to make sure everybody's aware it's coming. This is Nohema Graber, is that right?
That's correct.
And were you able to get a view of the wound to her head while you were there?
Yes, I think the next couple pictures will depict that more, but as you're standing there overlooking her, you can see pretty clearly that there's no visible injuries on the front of her body, her legs or arms, maybe some scratches, that sort of thing from the woods, but nothing that would be fatal. However, when you look at her head, there looks like there's a very egregious injury there.
Okay, that's what's shown here in Exhibit 125, is that right?
Yes.
And then was her head adjusted or picked up and you could see the wound a little bit closer?
It was pretty matted with blood, but you could tell that there had been a serious injury to her head.
And that's what Exhibit 126 shows, is that correct?
That's correct.
Okay. All right. Was Nohema Graber, after that area was processed, where would she have been taken?
So she would have been taken, because of the nature of the incident, to the Iowa Medical Examiner's Office, State Medical Examiner's Office in Ankeny, where an autopsy would have been done.
Okay. And then do you know Dr. Michelle Kedley?
Yes.
Would she have performed the autopsy on Nohema Graber?
Yes, she did.
And I know the report is in evidence, the entirety of the report, but ultimately what did you learn from Dr. Cavalier that would have assisted you in your investigation?
Yes, she determined that it was a homicide due to blunt force trauma.
To her head?
To her head, yes.
All right. Agent Bilda, let's go back to John Burnett, if we could.
Yes.
So whenever you arrived here, John Burnett was already at the Fairfield Police Department, is that right?
He had been there earlier. He went home, and then we called him back shortly after I got there.
And who did he come to the police department with, if you remember?
His girlfriend, Kedley. I can't remember her last name. Johnny Kedley.
And can you summarize for the court what information John Burnett was able to provide you and law enforcement that relates to the death of Nohema Graber, as well as Jeremy Goodale and Willard Miller, the defendant?
So this is when the case, the investigation itself became very fluid. John Burnett had told us that he had information on who had killed Mrs. Graber. Part of my job on the I assign people to interviews, to different tasks within that. So I assigned 2 agents to speak with Burnett and Kedley. They provided to us screenshots from Snapchats that he had received from Jeremy Goodale that were very graphic in nature, detailing the murder of Nohema Graber.
And did those Snapchats also implicate the defendant, Willard Miller?
Yes, they did.
Can you summarize that information for the court?
There's a couple important things to note. The Snapchats are often deleted as soon as you open them and close them, they become deleted. So there were several initial Snapchats that John Burnett was not able to save. The ones he did save talked about how Jeremy Goodale describes him and another person attacking Mrs. Graber in the park and hitting her with a baseball bat. He also says it was because she gave the wrong student a failing grade in Spanish. John Burnett would testify that some of the other information he had received, including the earlier Snapchats, would implicate Willard Miller in that assault and murder.
And just to be clear, the Snapchats that were provided by John Burnett to law enforcement were between John Burnett and Jeremy Goodale, is that right?
That's right.
And in those Snapchats, he not only implicated himself, but also the defendant in this case, is that correct?
That's correct.
And is that how the investigation then shifted to focusing on Jeremy Goodale and Willard Miller?
So what was interesting was when we had first got there were the Fairfield Police Department had listed Willard Miller as a suspect based on some statements he had made to someone else. Jeremy Goodale was not on the board, but obviously once we had the Snapchats, Goodale and Miller kind of rose to the top of the suspect list.
Before I move to the search warrants at both the Miller and Goodale residences, there was video, I'm not sure we touched on this yet, but there was video of the van of Nohema Graber entering and leaving Chautauqua Park, is that right?
That's correct.
Can you describe that for the judge, please?
It's a ring bell camera. We're kind of in a world now where lots of people have cameras when you ring your doorbell and it starts recording. So it was a house that was facing the entrance to the park, would have recorded the van entering the park around 4 p.m. on November 2nd.
And then was there video of the van leaving the park?
Yes, so the van left the park approximately 4:45 p.m.
And can you see in the van who's driving it when it leaves?
No, we can't see who was driving when they left the park.
Okay, Agent Villas, based upon the information that you had, search warrants were then executed at, we'll talk first about the Miller residence, is that correct?
Yes.
And there was also one executed at the Goodale residence?
Yes.
We've talked a bit about the bat that was found. Where was that at exactly?
We recovered several bats. I think we recovered 2 from the Goodale residence and then the 1 from the Miller residence, which would have been in Willard Miller's room.
Okay. With regard to the search warrant at the Miller residence, was anything else found of any evidentiary value to the investigation that you can recall?
His cell phone was seized. I don't think anything else in the Miller residence was of investigative value.
And just to preview this a bit, his cell phone was examined, is that right?
Yes.
And we'll talk a bit about that later. The Goodale residence, what was taken from the Goodale residence that was of any value, if you recall?
Yeah, there were several pieces of clothing that still had blood on them. The clothing was actually, we were able to made up that clothing with pictures from the Snapchats that Goodale had sent to John Burnett.
These are Snapchats with photos that were recovered.
That's correct, yes.
So other than the searches at the Miller residence, the Goodale residence, was that the only time you searched those 2 residences?
Yes.
Okay, and then you also searched the Chautauqua Park in that area, is that right?
That's correct.
The van would have been searched, is that correct?
Yes.
As well as the area around it on Old Glasgow Road?
Yes.
All right, any other areas that would have been part of this investigation that you would have searched where anything of significance was found?
I know the police department had received information where maybe the gloves that were used in the murder were located in a storm drain. They weren't able to locate those, but as information came in, the police department was very on top of conducting those searches.
Although we're going to cover this later with another witness in this hearing, Willard Miller was interviewed, is that correct?
He was.
By who?
Special Agent Ryan Kedley.
Okay. And was Goodale interviewed?
We attempted to interview him, but he invoked his rights and refused to talk to us.
And Jeremy Goodale was later interviewed through a proffer agreement, is that right?
That's right.
Okay. And that was also done by Agent Kedley?
Yes.
All right. Agent Valletta, there were other young people, high school kids that you interviewed, or you or other officers interviewed as part of this investigation.
Yes.
Was one of those young man by the name of Dill Herlin?
Yes.
What did Dill Herlin provide to law enforcement that was of assistance in determining who was responsible for the death of Nohema Graber?
So, Dill Herlin was he was at the top of the board, the whiteboard, as far as people we needed to talk to in the police department. He had told another teen who was, I guess, a relative of one of the jailers, so it kind of came secondhand, that Willard Miller had told him that if Nohema Graber comes up missing in the next couple weeks, not to contact the police. I had signed Special Agent Chris Spencer then to interview Dill Herlin at the police department, where he provided additionally where that statement was in fact true, and Dill Herlin also described the conversation he had with Willard Miller, in which Willard Miller stated that Nohema Graber's routes were very predictable and that he could easily hit her with a bat at the park.
And do you know what Dill Herlin's relationship was to the defendant, Willard Miller?
Again, he would be in that friend group. It's kind of hard to determine because they kind of call each other best friends, so all of them do. I would say he'd be a close friend to both Miller and Goodale.
Okay. Did you and others interview other friends or acquaintances of the defendant?
Yes, we did.
Was one of those Talon Sisimophone?
Yes.
I think I just mispronounced his name, but nonetheless, you talked to Talon. Is
Yes,
that right?
we did.
Can you describe for the court what information Talon provided you with regard to the death of Nohema Graber?
So on November 3rd in English class, he had a conversation with Willard Miller, in which Willard Miller told him he had caught someone with a baseball bat. I'm relatively old at this point. I wasn't aware of that term, but Talon interpreted that term, and I guess all the teenagers interpreted that term as catching someone with a baseball bat means killing them with a baseball bat.
Or at least striking them, correct?
Yes.
Was Talon able to provide any other statements that he had heard from Willard Miller?
I don't recall.
Okay. I'm not suggesting that he did. I'm just making sure we got it all covered. So, who is Zoe Fintel?
So she would have been the girlfriend of Jeremy Goodale at the time of the murder.
Was she able to provide some information, particularly with regard to location, on November 2nd of both Jeremy Goodale as well as Willard Miller?
Yeah, so she was a very interesting interview because she had actually met with Jeremy Goodale on November 2nd at Chautauqua Park around 4 p.m. So that would have been around the time that Nohema Graber was entering the park. She tells us that she observes Willard Miller walking down the path towards where the assault occurred. And Jeremy Goodale actually tells her she needs to leave the park. And so her last, I guess, view of Jeremy Goodale is Jeremy Goodale running down towards Willard Miller, towards the area where the assault would have taken place.
So Zoe Fintel puts both Jeremy Goodale and Willard Miller in Chautauqua Park on November 2nd of 2021. Is that correct?
Yes, together at the location where the murder happened.
Did she give you any reference as to what time this would have been today?
She said it was right around 4 p.m. on November 2nd.
Would that have been consistent with other evidence that you viewed in this case?
Yes.
Particularly as it relates to the van that was driven by Ms. Graber.
Yeah, so again, on the ring bell camera, the van would have entered the park right around at that time when Zoe Fintel's having that conversation with Jeremy Goodale.
Agent Willard, I want to shift a bit here. In any case, do you attempt to develop the motive for any particular action or death of a victim?
So that's a great question. In a homicide or a murder, motive isn't one of the elements. However, it seems if we can prove motive, it's what the jury, one of the things the jury wants to hear. So we were actually able to show not only the motive, but also the opportunity that Willard Miller would have had to kill Mrs. Graber.
Let's talk a bit about the motive. What information did you develop in this case that would have provided the reason for why Willard Miller would have wanted to kill Nohema Graber?
So it starts with the Snapchats from Jeremy Goodale, in which he says that Nohema Graber had failed the wrong student. We had known, due to the investigation from the Fairfield Police Department, that earlier on the 2nd, Willard Miller and his mom had met with Nohema Graber regarding his failing grade. We had retrieved some school records, emails that would show how Willard Miller was anguishing over how bad his grade was and how he didn't feel that Nohema Graber was a good teacher. And then eventually we do a search warrant on, or a celebrate, I guess, on Willard Miller's phone, which greatly details the motive.
Before we talk about that search of the Celebrite search, were you able to confirm with the Fairfield Public Schools that Willard Miller had a failing grade in Spanish?
Yes, he was getting an F at the time of Nohema Graber's death.
And you were able to confirm that he was actually a student with Nohema Graber, is that right?
That is correct.
Was Jeremy Goodale a current student of Nohema Graber's in November of 2021?
I don't think he was, and I think he actually did pretty well in that class.
Okay. He had had her prior as a Spanish teacher, is that right?
I believe that's correct, yes.
Concerning planning that went into the death of Nohema Graber, can you just briefly summarize what planning went into her death?
So it appears, according to Jeremy Goodale, that the planning began roughly 10 days to 2 weeks before her death, when Willard Miller started asking people to help him with the murder. So the planning between Goodale and Miller started around then. Later on, we were able to recover, basically we call it a prep email, where Willard Miller lists several of the items that he would need to commit the murder.
So about how far in advance of November 2nd did the planning start by the defendant with regard to Nohema Graber's death?
Yeah, so according to Dill Hurlin, it was about a week and a half. According to Jeremy Goodale, maybe 2 weeks. So, like I said, I would have to guess between 10 days and 2 weeks before the murder planning had started.
Did either Goodale or Miller engage in any surveillance of Nohema Graber prior to her death?
Yes, they did. Again, to refer back to Miller's statement to Dill Hurlin, was they were actually watching her to determine what her routes were. I think pretty early in their surveillance, they were able to determine that almost every day, or if not every day, after school, she would go to Chautauqua Park to walk.
Had they actually observed her engage in that walk prior to her death?
We can do almost a best guess. We can see that, I think it was the day before, they were staged to follow her out there, but she actually had a church event that day, so she didn't go. But if I recall correctly, we had video showing them kind of preparing to follow her out to the park.
So there was evidence of planning, would that be true?
Yes,
For a substantial period of time, is that the best way to characterize it?
yes.
I need to shift gears on the screen here. Judge, I'm almost done. I think I can describe this, maybe without putting it on the screen, but
We can also put it up on the Oscar.
Well, what exhibit are you asking Agent Willard to look at?
so this would be 130, which is the Google search, and 131, which is what we termed the prep list.
And defense counsel, you have copies of those, correct?
Yes, Your Honor.
Go ahead and let you either show or use whatever device you want to for Agent Willard.
So let's put exhibit 130, which is the Google search. Sure you can read that, right? There we go.
Much better, thank you.
Okay, so this is exhibit 130 that's on the screen. Do you see that?
Yes.
How is it that this document would have been created, if you know?
It's searches that are done on your phone. They're often they stay there forever. So when a Celebrite is done or a search warrant is done to recover those records, often the searches it's just something that people don't think to erase.
Okay, so there are a number of entries on this document that relate to a Google search created by the defendant. Is that right?
That's correct.
To be clear, this information came directly from his phone that you seized. Is that right?
Yeah, yes, that's correct.
On the far right side of this document, there are numerous entries that say Chaiden's iPhone. Is that right?
Yes,
Okay, so this is Chaiden's iPhone.
yes.
All right. If we could move to scoot it down a bit to 342. All right. So this is an entry that would have been a Google search. Can you describe at the left-hand box that we see in this exhibit what it is we're looking at here?
So this is essentially would be the motive for Nohema Graber's death, where Willard Miller is asking do students receive credit for class if the professor is seriously injured or dies more than halfway through the course.
There is a word here that says Cora, is that correct?
Yes,
Can you
that's,
tell us what that is?
yes, it's something it's a search engine where you can ask the question and then anonymous people will reply with an answer.
There are numerous entries that are very similar in nature that relate to what we've just looked at here in 342, is that right?
Yes,
Okay, also on this cell phone there is a date, is that right?
yes,
The fourth box over, is that correct?
yes.
What does that represent, if you know?
That would be October 24th of 2021, which would be roughly 2 weeks before the murder.
Okay, and then lastly, we're going to move to Exhibit 131. What are we looking at here in Exhibit 131?
So this would be an email. It shows that it kind of when it was created, when it was modified. So it had been modified on October 30th of 21. We call it the prep email. This is something that was created by Willard Miller, listing different items and that sort of thing that would be used eventually on the attack on Nohema Graber.
This was actually on the left hand side. This would have been created in September of 20. Is that right?
Yes, that's what it shows.
Right. And then modified on October 30th of 21, correct?
Yes,
Which would have been several days before Nohema Graber was murdered. Is that right?
yes,
Right. And this was created on a notes app on the phone. Is that correct?
yes.
You had sent an email earlier. Do you have evidence that this was actually emailed to anyone, or do you know?
That's just kind of how I read it, just because of the title and summary. I'm actually quite not very good at describing sometimes the difference. So yes, it is a roadmap.
Now, there are several items on here: garden gloves, plastic gloves, trash bag, Ziploc bag, wet wipes, and a backpack. Is that right?
Yes,
Would those items have been consistent with what was described in Jeremy Goodale's interview with regard to preparation prior to Nohema Graber's murder?
yes,
And were wet wipes found at the scene?
yes. There are several wet wipes at the scene.
And then there's a procedure that is also in this message, is that right?
Yes,
And it says stun, move off trail, empty compartments, load cargo, blanket cargo, deactivate compartment contents, leave bag by exit, transport, empty transport, safety stun, switch glove, deactivate article to bag, finalize the win, in parentheses it says secure victory, load into storage spot, don't forget to close the door to the ground, switch glove, move the sticks, wipe down tools, dispose article, and grab bag by exit, and then done. Did I read that correctly?
yes.
It's a rather cryptic message, wouldn't you say?
I would say it's very cryptic, and you don't really have to read between the lines to know what he's describing.
This would be at least partially consistent with the items that were found at the scene, as well as the circumstances that you learned concerning Nohema Graber's death. Is that right?
That's correct.
At this time, I don't have any further evidence or further questions for Agent Miller.
Defendant's cross-examination.
Your Honor, before I get started, I believe that we will have an exhibit. What number would you like to use for that exhibit?
The last number, or actually you guys used letters, was CCCC. So if you wanted to use quadruple D,
Your Honor, I could either do that, or this was previously admitted as a suppression exhibit M.
okay,
that
suppression
makes-
exhibit M is in the file. Yeah, go ahead. We can just,
May I approach the witness?
go ahead.
Agent Valletta, I'm handing you an item that was previously marked as suppression exhibit N. Are those the recovered Snapchat messages between Jeremy Goodale and John Burnett?
Yes.
And the recovered messages, just to clarify, Jeremy Goodale says that it was he alone involved in swinging the bat and involved in the physical acts relating to the murder, correct?
In the ones that you just handed me, that's what he said, but you also need to keep in mind there were other messages that he had sent to John Burnett that John Burnett was not able to screenshot.
And I'm clarifying because I think that there is, earlier in your testimony, you said that the recovered messages were the ones that implicated Mr. Miller, but in fact, these are the recovered messages, correct?
Yes.
And in this case, very specifically, Jeremy Goodale says, I walked up behind her and caved in her skull with a bat, correct?
Yes.
And each of the statements within the recovered messages, at least, are Jeremy Goodale's statements that he was the one who swung the bat, correct?
What you just read to me is exactly how it's worded. So.
And, Your Honor, I ask that the state, Your Honor, I ask that the court recognize suppression exhibit M as one of the exhibits for sentencing.
And I will, and I will just take judicial notice of the entire court file. If there's no objection from the state,
No, Your Honor.
go ahead.
Your Honor, could we step back to that? The defense may have some objection to taking judicial notice of the entire court file. Could we maybe address that after break?
We can, we'll take judicial notice of case M, or exhibit M for the suppression hearing.
Thank you, Your Honor. So, there is quite a bit of physical evidence collected, correct?
Yes.
And with regard to blood and DNA evidence, there was evidence found on the clothing of Jeremy Goodale that the blood of Nohema Graber, correct?
Yes.
There is no blood found on any item of clothing or anything related to Willard Miller, correct?
That's correct.
You referenced Jeremy Goodale's statements. Jeremy Goodale's statements were made in February 23rd of 2023.
Yes.
And then he made no statements prior to that.
No.
So any statements he made would have been after he had access to the DCI file, depositions, minutes of testimony?
Yes, that would be correct.
And those statements were made at a point in time when he was trying to obtain a deal with the state, and as part of obtaining a deal with the state.
Yes.
Then go back, you were at Willard Miller's home and part of those interviews. Is
Yes.
that right? Willard Miller had just had a meeting with Nohema Graber, right, the day of her death.
Yes, I think it was a couple hours prior.
And he and his mother both said that meeting went well.
I don't recall exactly. I remember, I think I saw an email regarding that, but I don't exactly recall what was said regarding that meeting.
Within his home, Well, within the interview, you found out that he now has a Spanish tutor.
I did not know that. No.
You didn't see that he had completed Spanish homework in his home?
From what I saw from the school records, it looked like he had a lot of incomplete homework.
Right. Within his home, did you find, when you were doing the search, find completed homework on his desk?
I wasn't part of that search. I don't remember seeing that recorded as evidence.
Now, Jeremy Goodale made statements about items that were discarded in a storm sewer, correct?
Yes,
None of those were recovered.
that's correct.
And let me step to the list that was provided to you from Mr. Miller's phone. There were a number of items on that list that were not at the scene, like hedge clippers, correct?
Yes.
And in fact, that list initially was created at a time before Mr. Miller had ever met Ms. Graber.
Okay, so that's how I would interpret it, although someone tried to explain to me that that could have been the 9/20, 2020 date could have been a different list, and then this one was just modified, so it was literally the original list was erased and this one was created, but I have no way of knowing if that's true or not.
So the initial document, whatever it said, was created prior to even being in Ms. Graber's class.
Whatever that original document said, but again, I understand what you're saying, that it looks like the prep list was created on 9/20, but I was also, the tech people were trying to explain to me that just because it was created then doesn't mean that content was created then.
And then you talked about a statement made to Dill Hurlin about if Mrs. Graber goes missing. Mr. Hurlin thought that was a joke, correct?
I think a lot of the students that received troubling statements from both Miller and Goodale didn't feel that it was, like maybe they were hoping that that wasn't true, but this isn't like normal type of conversation either.
Well, let's talk about before November 2nd,
Okay.
2021. Any of those statements were perceived as a joke to anyone who Mr. Miller spoke with, correct?
Yes, I mean, I don't know if they took it seriously. However, Dill Hurlin must have had some concern because, like I said, the Fairfield Police Department didn't know about it, at least before I got there.
But again, that was prior to the disappearance of Ms. Graber. Dill Hurlin expressed that he thought it was a joke. I mean, he said, I thought he was joking, correct?
Correct, yes.
And you looked at Mr. Miller's phone. Mr. Miller's phone also showed that he set up counseling that he ended up going to, well, that he had set up counseling, is that correct?
Yes.
And it looks like he had set up counseling prior to the death of Nohema Graber, but then ended up going the following day. Is that right?
The last time I was aware of him, I guess counseling would have been a few hours before that.
Okay, let's step back. He did learn that Chaiden Miller had turned in some homework during the meeting with Ms. Graber.
That could be true. Again, just based off the current caseload, I guess, for Mrs. Graber, it showed that he had a lot of incomplete assignments, but obviously she wasn't able to update that.
Well, you had learned that he had turned in some homework.
Are you referring to that meeting before, on the
Yes.
same day, on November 2nd?
Yes.
I believe that's true.
And he had photos on his phone of Spanish homework.
I believe that's true.
And the photos of the Spanish homework were after the search about what happens if your Spanish teacher disappears, correct?
Yes.
And both Mr. Goodale's statements and the phone records from both Mr. Goodale and Mr. Miller show there was minimal communication between the two of them about anything, including about going to Chautauqua Park during those 2 weeks prior to Ms. Graber's death.
Are you saying there's no electronic confirmation of
Correct.
conversation? And we have no idea how many times they would have met in person?
Correct, but there is
No,
minimal, if any, communication between the two of them.
correct, they're not emailing or texting each other about the murder.
And Jeremy Goodale said that they really didn't talk about it, that it was somewhat spontaneous, that they had one discussion, didn't he?
Well, I don't know, I mean, 2 weeks would be, in my mind, that's actually quite a bit of premeditation. I usually don't see that. I could speculate all different kinds of reasons why you wouldn't want to talk about it a whole lot. My first thought would be is that...
Your Honor, I'm going to object as non-responsive. My question is, Jeremy Goodale said that they only spoke one time or 2 times prior to November 2nd, correct?
You can answer the question, Agent Warden.
I believe it was, yeah, roughly 2 times, yes.
And just to be clear, the physical evidence in no way is, the physical evidence is consistent with Mr. Miller's statement that he was a lookout and that Mr. Goodale struck the fatal blows, correct?
Well, I would say there was physical evidence recovered at the scene that would be consistent with Chaiden Miller's prep list also. So physical evidence would also correspond with the pre-planning done by Miller, as well as then some of the statements that Goodale made.
So I'm going to clarify, you said that physical evidence would be consistent with prop list. The physical evidence is also consistent with Miller's statement that Jeremy Goodale was the one who had the bats, correct?
I don't think Goodale would dispute at one point he held onto the bat, so I would say that physical evidence, as far as showing fingerprints or Goodale's DNA, no. However, Goodale has openly admitted that he had swung the bat. So, am I answering your question?
The only question I was asking is there's no physical evidence that is in dispute with what Mr. Miller said.
As far as him swinging the bat?
That Mr. Miller said that Mr. Goodale was the one who swung the bat. The physical evidence doesn't disagree with that.
I see what you're saying, yes. There's no physical evidence to dispute that.
I have no further questions.
Mr. Brown, any other questions?
Just one thing that relates to the statements. The only evidence we have is what people tell us with regard to who swung the bat and how many times, correct?
That's correct.
We have physical evidence that would suggest that Nohema Graber had blunt force injuries consistent with getting struck by a baseball bat.
Yes.
As far as who swung it, we have to rely on what Jeremy Goodale says and what Willard Miller may tell us, correct?
That's correct.
There are no other eyewitnesses, right?
There's no eyewitnesses, however, Willard Miller did tell Talon that he swung a bat too.
I was getting to that.
Okay.
So, but Willard Miller makes admissions that you've already identified, one of which would have been to Talon, another to possibly Bill Hurlin, that he was directly involved in striking Nohema Graber with the bat. Is that right?
That's correct.
Okay, that's all.
Anything else Mr. Brand said?
Jeremy Goodale made statements to many people that he was the one who swung the bat, correct?
The only statements that I'm aware of that Goodale would have made would have been the night of the murder, and that would be through Snapchats and maybe, I think, a phone call to one other kid. So I don't know if saying that he told a lot of people, I would almost say probably Chaiden Miller probably told more people than Goodale.
Well, Mr. Goodale was on PlayStation and talked with more than one person on PlayStation.
Yes, he did.
And he sent out Snapchats to more than one person, but we know that at least John Burnett is the one who captured that, correct?
Yes.
And Mr. Goodale also went to a party where he referenced the blood on his shoes, correct?
Maybe. I'm not, that seems familiar, but I can't say for sure if I remember that.
I have no further questions.
Nothing else.
Okay. Agent Valetti, you can step down. We'll take a 10-minute recess and reconvene at 11 o'clock.
Just real quick, since where we're at on time, Mike Heinersey from Oakdale is here. We would probably just call him next since he came. I told him 11 o'clock, so I think he's got to get back, if that's okay with the court.
Fine with me. On recess.
Former First Lady Michelle Obama suggested that Americans weren't ready for her natural hair, instead opting for a straightened look. GBH's Kelly Crossy joins us to discuss this and the denial of Mariah Carey's application to become the official Queen of Christmas. Oh no, it's all to come. Boston Public Radio, 89.7 GBH.
Live from NPR News in Washington, I'm Dwayne Brown. A heavy snowstorm is hitting the Great Lakes region with snowfall in Buffalo, New York, reaching historic levels. NPR's Amy Held tells us much of the city and surrounding areas have shut down.
Even by Buffalo's no stranger to snow standards, this storm is sticking out. The NFL taking the rare step of moving Sunday's Bills game against the Browns out of the city to Detroit. With visibility near zero in Buffalo, officials banned motorists from roadways, though they later shifted the ban to an advisory.
There is still the extreme when it comes to the heavy snow.
4 feet forecast by the time it ends Sunday, says Dan Neverth, Erie County Emergency Services Commissioner.
This lake effect snow has a very, very high water content, very, very heavy, and more likely to take down potentially branches and power lines.
Videos circulating online show the eerie phenomenon of thundersnow, with lightning illuminating the snowfall. Amy Held, NPR News.
North Korea test-fired an intercontinental ballistic missile today that fell into the sea off the coast of Japan. As NPR's Anthony Kuhn reports, there have been 50 test launches in the past 2 months.
South Korea's military said the missile traveled about 621 miles to the east, reaching a maximum altitude of nearly 3,800 miles. The missile landed about 124 miles off the coast of northern Japan's Hokkaido prefecture. Japan's defense minister said that with a flatter trajectory, the missile could have reached the U.S. mainland. The U.S. and South Korea responded by dropping laser-guided bombs in a simulated attack on mock enemy missile launchers. At a summit in Thailand, Vice President Kamala Harris called the North's test a brazen violation of UN Security Council resolutions. Russia, which has vetoed proposed UN sanctions on North Korea, expressed concern about the situation on the Korean peninsula and called for all parties to avoid confrontation. Anthony Kuhn, NPR News, Seoul.
More Twitter workers are leaving the social media company after its billionaire owner gave them an ultimatum: either pledge to hardcore work or quit with severance pay. This comes after Musk paid $44 billion for Twitter last month, then laid off half of the company's 7,500 full-time employees. NPR's Shannon Bond says it appears the company is losing some critical expertise.
Musk overpaid for this company, and he has all this debt to service, so he's under pressure to cut costs, increase revenue. This week, he told remaining workers that they had this choice: stick around the new hardcore Twitter, work long, intense hours, or they could leave with 3 months of severance. And they had to decide by Thursday afternoon. And that time rolled around, and it appears a lot of people are choosing door number 2. They're leaving Twitter.
NPR's Shannon Bond. It also comes as the platform gears up for the World Cup, one of the busiest events on Twitter. You're listening to NPR News.
Good morning. With the latest from the GBH Newsroom, I'm Henry Santoro in Brookline this Friday. The MBTA board is giving qualified support to the T's plan to revamp its bus network. It's the first major changes to the system's bus route in some 60 years, 6-0. Quincy Mayor Tom Koch is on the board. He says he's approved the plan, but only if changes can be made during implementation. He says that even with recent revisions to the proposal, fellow mayors have told him that they're worried about some route changes.
And I understand there's no perfect plan, but as we continue to move forward with it, that the T administration will be open to suggestions from some of these communities and try to resolve some of these disparities in their view.
Some board members and elected officials say they want more public input before permanent route changes are made. U.S. Senator Elizabeth Warren is helping to take the lead in Congress's investigation of the collapse of the FTX cryptocurrency exchange. The Globe says that Warren and Senator Dick Durbin sent a letter to FTX and its former leader, Sam Bankman-Fried, a native of the Berkshires, we might add, asking for answers to questions about its misuse of billions of dollars that belong to its clients' funds. Regulation of the crypto market has been on Warren's radar for quite some time. The FTX FTX meltdown has also brought the names of several celebrities and sports stars to the forefront. People like Tom Brady and Steph Curry and Shaquille O'Neal, Larry David, Gisele Bündchen, and the list goes on and on. In sports, the Celtics in New Orleans tonight. The Patriots host the Jets at Gillette on Sunday. This is GBH News.
Support for NPR comes from NPR stations. Other contributors include Dataiku, a platform for everyday AI to help organizations make AI part of their daily business, designed to elevate people, teams, and companies. Dataiku.com.
Browdy, I am Marjorie Egan. You are listening to Boston Public Radio 89.7 GBH. We are broadcasting live as we do every Tuesday and every Friday from the Boston Public Library, and we are streaming online at youtube.com/GBH News.
And we're joined here live, as we are every month, at the Boston Public Library by the mayor of Boston, Michelle Wu. She'll be with us for the hour, taking our questions and your calls, as she just marked 1 year in office. Mayor Wu, it's great to see you.
Thanks to be here, as always.
Yeah, thank you very much.
By the way, can we get this out of the way?
Yes.
Marjorie said you were a class act.
Yes.
And we are classless.
We're deadbeats.
You brought us something yet again. What'd you bring today?
So this was, I just like to take every opportunity to show and tell our local amazing small businesses. We had a press conference in Mattapan this morning on home ownership. Right around the corner is the community institution, Le Foyer, a bakery, a Haitian bakery that has been there forever and ever. So these are patties, chicken and beef patties. I had mine in the car already.
Thank you so much.
Now, I don't want to put you on defense, but in about an hour or so, Joanne Chang is coming. And I'm guessing she's bringing some stuff too, so there may be some real competition
So
today,
at my wedding reception, we had served, for desserts, we had served two things: her tartlets when flour
For just $67, you can make as many videos as you want, and you never need to pick up a camera.
And prior to that, where were you employed?
I worked at Anamosa for 18 years before I went to Oakdale.
Has your career in corrections all been here in the state of Iowa?
Yes.
And as the warden, just generally, what are your duties?
Oversight of anything and everything, being fiscally responsible, making sure that the facility is secured and running in an orderly fashion, all those different things. Me and my team tasked with all of that.
Right. And you had indicated that you were part of creating the youthful offender program. Is that correct?
That is correct.
Pursuant to the federal law that you had talked about the Prison Rape Elimination Act. Is that correct?
That is correct.
All right. So how long has the youthful offender program been in place at Oakdale?
It's been in place with our department for 10 years and been at Oakdale for 5, about half of it.
Okay. And is it staffed full-time by counselors and other employees of the Department of Corrections?
Yes, it is.
And is there a special program that is utilized for young men who are put into that program?
Yes.
Can you just generally describe what the programming is in the youthful offender program?
Yeah, so typically the size of the program is obviously, is dictated by the courts, but we usually have somewhere around 10, maybe 15 on the unit at any given time, and each of those that are admitted has the opportunity, actually, let me rephrase that, it's a requirement if they don't have their education done for them to go to schooling 16 hours a week, and once they have completed that, they can focus on some other things, but a lot of times that's their full-time job, is getting their schooling done. We also have some programming that we offer. It's called moral recognition therapy. It's a cognitive-based program. We teach them some life skills. They all have a significant amount of one-on-one time because with their counselor and psychologist, because it's a smaller unit, and so there's opportunities to meet with them on a more regular basis than there would be in a traditional general population setting.
You had mentioned earlier that it's sight and sound separated, is that right?
That is correct.
What does that mean?
That means that no adult prisoner inmate can be on the unit unless there's a staff member directly with them at all times. So nobody else lives on the unit other than the youthful offenders, and the only time other offenders are on the unit is if it's absolutely necessary.
And is it located on the same campus as Oakdale, the men's prison?
Yes.
Is it a newer facility?
No.
Okay. So, Mr. Heinrichs, in this case, Willard Miller is almost 18. Assuming he's sentenced to the prison sentence, he would go to Oakdale, is that right?
That is correct.
Even though he has about 30 plus days prior to his birthday, maybe a little bit less, even, would he still be placed in the youthful offender unit?
Yes, he would.
And would he be able to take advantage of whatever programming can be implemented in that short amount of time?
Yes, he would.
Even though it's a short amount of time, would your staff make an effort to engage in the programming that you just mentioned?
Yes, they would.
Is there any possibility that even though he might move to the adult side of Oakdale once he turns 18, that programming would follow him?
Yes, it would.
Okay. Now, I want to talk a bit about younger offenders that are adults. Is there programming that is different for, say, an 18-year-old that is going into the Department of Corrections as opposed to somebody who may be a habitual offender or is older?
Our programming is based on the assessments that are done, and those assessments will be done once the individual comes to our facility, but the programming is not any different. We teach the same for the most part, with the exception of the life skills piece. The MRT, the moral recognition therapy, is a huge piece of our department, so it's taught in different folds across the state. So regardless of whether he was in the youthful offender unit or at another facility or in our general population, he would have those opportunities.
And once Willard Miller would move to the adult side of the prison, do you have any idea what his programming might entail?
I do not without the staff doing the assessments that they do, and gathering all of that will dictate what a lot of that looks like.
And it would be individualized to him, is that correct?
Yes.
Is that the same for any inmate that comes into Oakdale?
Yes.
Okay. Once Willard Miller would transfer to the adult side of the prison, is there any guarantee that he stays at Oakdale for the near future?
No.
Okay. Where might he go, be assigned to other facilities? Do you have any idea what that might be?
I mean, once his counselor that is with him when he's on the youthful offender unit, if he would be on the youthful offender unit, we'll have those discussions with our placement office. But hypothetically, if he doesn't stay with us, there's a high probability that he would go to ISP, Iowa State Penitentiary.
At Fort Madison?
Correct.
Is that because of the nature of the offense that he pled to?
Correct.
You and I had a conversation prior to court in the previous week or so where we discussed mandatory minimum sentences. Do you recall that?
Yes.
I had asked you a question regarding whether or not programming is different for someone who receives a mandatory minimum as opposed to someone who does not. Do you recall that?
Yes.
Can you provide that context to the court as to how programming is implemented given those two factors?
Yes. So, the need outweighs what we have the ability to do. And what I mean by that is if somebody has a mandatory or, 25 years, whatever the case may be, that person's not going to get into programming most likely anytime soon. It will be closer to the end of their mandatory because we have to focus our resources on those that are releasable in a quicker fashion. So those that have a longer sentence with a mandatory don't necessarily get into programming sooner, with the exception of education.
Okay. So if Willard Miller comes to you and is a youthful offender and goes into the first unit that you described, because he would be getting out of that so quickly, would he become a priority as far as programming? Or do you know?
Not necessarily, probably not. I don't know that for sure. But if you're talking, 6 weeks, it's going to be difficult. But they would at least look at the possibility of starting it. Yeah.
Okay. And then whenever he shifts to the adult side of Oakdale, let's say he gets a 30-year minimum sentence. Whenever you say that he will receive education, at least initially, what do you mean by that?
Well, by law, anybody that's under 21 is eligible to go to school. So if they haven't completed their education. So education is a little bit separate from the other programming piece that I talked about because of the age. He would be eligible to finish his HISET.
His what?
HISET, that's what, GED.
Okay.
But we go by HISET now, HISET.
Okay. And if he's already received an equivalent a high school diploma, would he be able to engage in education or classes that would be post-secondary?
Yes.
So if you're at Oakdale and you're a prisoner, you can attend college-level courses. Is that right?
That is correct.
Or at least get that type of education.
That is correct.
Is it possible for an inmate like Willard Miller to gain a college degree if he's in prison?
Yes.
And how does that happen? How does that work? Can you describe that for us?
So each prison is a little bit different, because it's regional, and our partnerships are based on community colleges on where we're located. So our agreement is with Kirkwood. You got a place like Fort Dodge that has an agreement with Iowa Central Community College. Anything that's beyond the basic level of education has to be paid for by someone other than us. So whether the inmate has the funds or his family has the funds, and then we can work with the community colleges, and then there's also some online opportunities that people can do to go even farther. I've seen people get bachelor's degrees during my time in the Department of Corrections. So it's kind of depends on where you're at, but the opportunity is there if you have the funding and you're able to do so.
And once the defendant turns 18, other than education, is he able to be employed while he is an inmate at Oakdale or any other facility?
Yes.
Can you describe that for us, please?
Yeah, I mean, we employ a variety of different people because we need those labor-type jobs to be able to run the facility, so it's going to depend on where he's at, but, you know, we're talking laundry, maintenance, dietary, all these different things that you would need inside of a school, of a prison, of a community. We have people that assist with ADLA work, with hospice stuff. There's vocational programs that are available depending on what the facility you end up with. You can get a trade, you can get apprenticeship certified, and each facility that we have in the department has certain ones that are geared towards what they have at their facility.
So even though if there were a substantial minimum that the defendant would have to serve, he could go to school, receive an education, and be employed while he's a prisoner. Is that correct?
That is correct.
All right. Thank you. That's all I have. From the defense.
Any programming other than having a job or education would likely wait until closer to the end of any mandatory minimum. Is that correct?
Yes.
On the other hand, if there was no mandatory minimum, programming would start immediately.
Not necessarily.
It would start sooner?
It depends on, if you're speaking of this sentence, I don't know what you mean by that. So it's going to, the assessments that are done are going to dictate a rough figure of when it would be appropriate for somebody to get into programming. The mandatory minimum piece would it's more concrete, it's more black and white. But even without the mandatory minimum, aside from education, there would not be an opportunity for programming outside of the full offender unit, most likely. Now, I can't speak for where he would end up, but I'm just basing it on everything that I've known for the last 21 years of working for the department.
But a mandatory minimum tends to delay programming until you get towards the end of that mandatory minimum.
That is correct.
And you haven't reviewed anything specific to this case and to Willard Miller, correct?
No.
And you're only testifying about programming. You're not a psychologist, correct?
No, I'm not.
No further questions.
Anything else for this witness?
Nothing else. Thank you.
Thank you, Mr. Hennessy. State may call the next witness.
Thank you, Your Honor. The state calls Special Agent Ryan Kedley.
Do you promise to affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat.
Good morning, Agent Kedley.
Good morning.
Before we get started, you were in the room here when Special Agent Valletta was speaking previously, correct?
I was, yes.
Okay, so I might brush through some of the things that Special Agent Valletta had already spoken about, and if I'm missing something, please give me a holler, would you?
Sure.
For the record, could you state and spell your name for the benefit of the court reporter?
Yes, my first name is Ryan, R-Y-A-N, last name Kedley, K-E-D-L-E-Y.
And Agent Kedley, what is your profession?
I am currently employed as a special agent within the Iowa Department of Public Safety's Division of Criminal Investigation.
And you have a specified assignment or unit within the Division of Criminal Investigation?
I do, yes.
And what is that?
I work within the DCI's major crime unit, which specializes in high-level violent crimes throughout the state of Iowa. This position I've occupied since 2014.
And do you have a regional assignment?
I do, yes.
And what is that?
So my specific office is located just outside the Quad Cities, but my general area of responsibility within which I work is East and Southeast Iowa.
And you heard Special Agent Willard talk about the details of the investigation into the death of Mrs. Graber, correct?
I did, yes.
Could you walk us through what was going on in your professional world on the day of that assignment when you were down here in Fairfield?
Yes, so approximately around the same time that Agent Goodale was contacted and directed by our immediate supervisor to respond to Fairfield with regard to this missing person death investigation, I was also called to respond and provide any sort of investigative assistance necessary. Once I arrived there at the Fairfield Police Department and the Jefferson County Sheriff's Office, I met with Agent Valletta, also with Agent Richard Vale, V-A-L-E, also of the DCI, as well as local investigators to get at least an initial briefing on the status of the investigation up to that point.
When you arrived on scene, had the investigation proceeded and progressed to a certain extent?
Yes.
What kind of a scene were you walking into?
And so at this point, by the time that agents of the DCI had arrived there in Jefferson County, we had been advised of Miss Graber's status of having gone missing and then being located deceased at Chautauqua Park. And so as part of that, being advised of that information, under the direction of Case Agent Villada, Case Agent Villada begins delegating certain responsibilities to assisting agents and officers within law enforcement. Those responsibilities can be anywhere from crime scene management to neighborhood canvas interviews to person of interest interviews.
And is it fair to state that upon your arrival and engagement with this case, it had become a homicide investigation?
It certainly appeared to be, yes.
And what was your specific assignment or delegation?
And so initially, as we were going through the briefing, we were advised specifically of the information that John Burnett had begun providing information indicating that he was aware of the person or persons responsible for the death of Nohema Graber. And so Case Agent Villada had requested that I meet directly with Mr. Burnett and Katie McGuire, I believe it was his girlfriend, there at the Fairfield Police Department to further discuss the information which they both held.
And the information that they both held, where did that lead you in your investigation?
That information, detailed through the course of several screenshots of Snapchat communications, led us to identifying Jeremy Goodale and Chaiden Miller as being certainly persons of interest and suspects in the death of Nohema Graber.
Based on this information and your interview with those two individuals, what investigative steps were taken?
And so after the initial interview of Mr. Burnett and Ms. McGuire, search warrants were offered for the search of the persons of both Mr. Goodale and Mr. Miller, as well as their respective residences.
And were you delegated to engage in the execution of either or both of those search warrants?
I was, yes.
Did anything happen in between the signing of the warrants and the execution of the warrant?
Yes.
What was happening? What else was happening in Jefferson County at that time?
I believe in the very, very rural southwest Jefferson County, a suicidal subject was located and a standoff had begun that had stemmed from a domestic disturbance. And so because all of the law enforcement resources in the county of Jefferson had responded to that location where the standoff was in progress, agents of the DCI also responded to assist delaying the execution of the aforementioned warrants.
So in the middle of this homicide investigation, there was a completely separate investigation that you also were a part of?
Yes, that's correct.
About what time were you able to execute the warrants that were signed?
It was very early morning, around the time of 5 o'clock. It would be best documented through my own narrative, which is detailed in the case report, but very early morning on November 4th. I specifically was delegated the responsibility of accompanying other local officers to the residence of Jeremy Goodale to hopefully locate Jeremy, execute a warrant for his residence as well as his person, looking for, among other things, evidence associated with the potential crime, as well as a cellular phone device.
And I presume that other officers executed a similar warrant for the residence of the defendant?
Yes, that's correct.
At some point, you became familiar with Mr. Miller, correct?
I did, yes.
When in the course of this day did that take place?
Well, certainly during the course of the interview of Mr. Burnett, when I had discussed with Mr. Burnett and Kedley McGuire the details of those Snapchat communications, they had also indicated that there was other communications specifically identifying Mr. Miller as working with Goodale on the execution of the murder of Graber.
And take a step back to the execution of the warrant. Were there individuals taken into custody via these warrants?
Essentially, yes.
And who was taken into custody?
Both Jeremy Goodale and Willard Chaiden Miller.
And after Mr. Miller was taken down to the Jefferson County Police Department, you had an opportunity to speak with him?
I did, yes.
And he signed a juvenile waiver of his Miranda rights, correct?
He did, yes.
Are you aware of whether or not Mr. Goodale had conversations with law enforcement of any substantive nature on that day?
None of any substantive nature. I myself had addressed Mr. Goodale at his residence and then again at the police department. I assisted in the securing of his cell phone and then in the acquisition of any items of evidentiary value taken off of his person. But in terms of any further interview, that did not take place on that particular morning.
You generated non-testimonial evidence, but no testimony from Mr. Goodale?
That's correct, yes.
And we'll get to this down the road, but later on in this case, you were able to sit down in person with Mr. Goodale and have a conversation with him, is that right?
I was, yes.
Okay. Going back to your interview with Mr. Miller, this interview was audio and video recorded, was it not?
It was, yes.
And in a couple of minutes, I'd like to play some excerpts of that interview. But could you just kind of give us a rough thumbnail sketch of your conversation with Mr. Miller, how it started, and some really kind of relevant points of that conversation with Mr. Miller starting at the beginning?
Yeah, so again, setting the stage, Mr. Miller was woken up from his home and brought to the local police department for the sake of being interviewed as part of an ongoing homicide investigation. And so he was also subjected to a search warrant. And so upon meeting in person with Mr. Miller and identifying, introducing myself and Special Agent Vale, who assisted on this interview, we had initially advised him of his juvenile waiver Miranda rights. He had elected to sign that form and then permitted us to continue questioning him. For the better part of the first section, several minutes, if not 20 to 30 minutes of the interview, it was basically laying the groundwork of understanding the fundamental basis of who Chaiden was, what his role within the school was, how he knew Miss Graber, how his life in general was going. I would say that conversation was very cordial between myself, Agent Vale, and Mr. Miller.
Would you be able to classify or kind of describe Mr. Miller's demeanor during the course of this initial conversation?
Certainly compared to several other interviews which have turned out to be those of suspects, I would describe Miller's demeanor as being remarkably relaxed, especially given the circumstances of his age, the nature of the interview, the time of the interview, the fact that he was so comfortable and open, seemingly open with investigators in that opening stage of the interview, I felt was very remarkable.
Now you just qualified your statement seemingly open. Did that initial conversation that you had with Mr. Miller, let's call it conversation one, did the facts that were unearthed or attested to by Mr. Miller change as the conversation progressed?
Yes, they did.
At what point did you kind of note that maybe there was more to this story and maybe Mr. Miller was holding back or changing some of the relevant facts of this case?
Well, early on in the interview with Mr. Miller, while trying to get to know Mr. Miller as best I could, one of the questions that I had asked him was who were some of his close friends? And I felt that it was notable in his response where he listed several friends, but one of them was not Mr. Goodale himself. Not that I know him well enough to say that that was definitively untrue, but I did think that it was notable to circle back around later on in the interview to confirm that.
At this point of the interview, you had two suspects, principal suspects in mind, correct?
That's correct.
And did you have kind of some foreknowledge that they were close?
Yes.
Mr. Goodale and Mr. Miller?
Yes.
So it would stand out that Mr. Miller would indicate Mr. Goodale was a close associate?
Yes, it would.
And during the course of his essentially running through his day on the day of Mrs. Graber's death, did he indicate to you initially that he had spent any time with Mr. Goodale?
No, he did not.
Did that later come out that it was actually a substantial portion of his day was with Mr. Goodale?
Yes, it did.
Okay. What are some other factors that might have kind of tickled your concern about Mr. Miller's story?
Well, in detailing his life events throughout the course of that day on the afternoon and evening of November 2nd, he was pretty confident in the way he exhibited that information of he had gone from having a meeting with his mother and Miss Graber at the school to going to the office of his mother where he continued to do homework while his mother worked, and going from there directly to his home where he spent the remainder of the evening. As we reiterated that account, he began to change that account. One of the initial items that he changed was the fact that who he had run into. Upon first saying that he had not come across Jeremy Goodale throughout the course of that afternoon and evening, later on he admitted that sure enough he had. And to clarify, this was an interview that was taking place approximately a day and a half after the information we were discussing. So I would have presumed, in spite of the fact that it was early morning, that he would have had a pretty good recollection of what exactly happened and who he came across. And so after initially denying running into Mr. Goodale on his way from his mother's office to his home, then he came around and said, actually, yes, I did run into him, which I found a bit concerning that one small point would be omitted, again, given the circumstances and the timing of the interview.
Did you speak with Mr. Miller about the last time he saw Mrs. Graber?
I did, yes.
And did that story change?
Yes, it did.
Did you speak to him about his physical whereabouts the day of Mrs. Graber's death?
Yes.
And did that story change?
Yes.
How many versions of the story would you say that Chaiden spun for you during the course of your interview?
Well, there were certainly multiple versions, but within some of the later versions that he provided, he would add details as I would break down those versions. For example, in addition to what he was doing specifically, how those actions were taken.
Mr. Miller originally denied having any knowledge about the death of Mrs. Graber, correct?
That's correct.
And later on, he talked about actually witnessing a part or a portion of her demise, correct?
Yes, he described an incident where a group of masked individuals, numbered somewhere between 6 and 8, had pursued Miss Graber in Chautauqua Park. Miller described hearing what he described as a thud, and then looking down into Chautauqua Park and seeing this group of masked individuals carry some sort of object into the woods, which he had assumed was Miss Graber herself.
Now, did Mr. Miller, was he able to provide for you the names of any of these 6 to 8 masked individuals who allegedly drugged Mrs. Graber into the woods?
Not specifically the names of those individuals. No, he was not.
Were any names kind of generated by Mr. Miller during the course of this interview?
Yes.
And without listing all the names per se, in your later conversation with Mr. Goodale, were any of the names consistent?
So during that initial interview with Mr. Miller, one of the questions I believe I asked him was, were there people out there that he felt or knew about that may have wanted to do harm to Miss Graber? He had actually identified that, yes, there were several people that had gone through Miss Graber's class and had ill feelings towards Miss Graber, and then also at least provided, I believe, at least 3 specific names of classmates of his who he thought were capable and had ill feelings towards Miss Graber.
In your later conversation with Co-defendant Goodale, did Mr. Goodale tell you any individuals that Mr. Miller maybe had a beef with or had troubles with?
I believe that he said that he didn't have any issues of bullying, but he did have some disagreements with some of his classmates/associates at Fairfield High School.
And were any of the names that Mr. Goodale listed as people Mr. Miller had problems with at high school the same names as he listed as being involved in the death of Mrs. Graber?
I believe that they were, yes.
Your Honor, at this point, the state has 30-minute video that it intends to play, which is an excerpt of the interview with Mr. Miller. Let's play it now, or with the court, they take a lunch break.
Let's get started with the video.
And for the record, Your Honor, the state intends to play excerpts, 30 minutes of excerpts of Exhibit 128, which is already in the record.
do, yeah. I'm sorry. I do, yes.
Is this the room that you conducted a interview with Chaiden Miller?
I believe it is, yes.
Yeah, that's what I was over with. And then I just Tuesday, I got in like 12:40, and then did my morning routine, and then went to school to meet with Ms. Graber.
Okay.
At 1:15, and
So you guys know your Spanish program go. You're there about 1:15 for me. You know what time you meet there? 2:30 meet. Okay. And obviously Miss Graber, you see her meet with you guys, or she's
No, I know that she's the school has said that the last time they see her on campus, that they can afford. I know that she's for school that every year, you can stay an hour, however long. For kids coming in and doing her Goodale, she's creating everything good. So, she was at 4.
Okay, very good. So, as Dick mentioned, we're helping out with the investigation, trying to figure out what happened with Ms. Graber. What do you think happened to her?
It's kind of like she's a very routine person. So they like her
And when you say she's very routine, what do you know about her that would indicate that she's very routine?
Well, she's always on time. She's always here. She says she'll be where she said that. I don't have so much of a personal relationship with her, but I know people that do. We're not here and stuff like that. She's just
And who knows of that well that knows her routine?
Caitlin, I don't know, she's still in Spanish.
And you know her well enough to know that she's like very routine. I mean, one of the things we're trying to do is trace steps.
And so because the time is so small, you can get information about anybody at the school frequently enough. You just ask for you can just it's just kind of lingering. So it's just information.
Yeah,
pretty easy. I know that when she did it in Mexico, she does this. Mommy in my bag, I don't know.
Right.
I think she's at least finished, and there's 2 weeks left. I'm gonna share London. I don't know much about their relationship. And her dad, I think, was in Mexico.
Yeah.
And she has other opportunities, but I don't know one.
Sure.
But they don't know. Good knowledge of what
Okay. Do you know of anybody out there that would have serious gripe with Ms. Graber that may want to hurt her or something?
I know there's one kid that always say about the music classes, and they don't like her. She's kind of an asshole sometimes. Not really sure if I heard her. I don't know. I heard her really being Spanish. I don't know. I don't really know this. And then just yesterday, my dad, he had gone and actually had meetings with her because I had information with him about her and how his Spanish is kind of shitty around here. And so he's like, okay, we'll talk to her. And he just told me yesterday on private therapy that he didn't want to tell me anything because I was going to be seeing her, but apparently so. I live in Africa the same night. Her house got AIDS and TB, and I left a little Spanish. I got all the same time, and that meeting, Ms. Graber asked me about it. I'm not asking if she was suspecting me.
And so, again, we're not here to come down on you if you were involved in hanging or a teaching, but if you were involved, we want to get out of the table now so we can identify that and move on from it. Okay, so were you involved? You were not involved.
I have no idea. Usually people, there's other times you can find out, so in a small town, people can be boasty, you never know what an over goes large exercise. Well, it's very easy to incorporate in that, right? It's very well. And going back to mess around with it. That could be an issue, but so the high school is pretty. Yeah, so tell me this, is there any, can you think of any reason why somebody might say you were involved in that? Because we got into class. Okay. But like with a little bit more specific, like anybody might say like, hey, listen, I know for a fact he was involved. Not I think he was, but I know for a fact he was. What's the question? The question is there any reason why somebody might say like, I definitely say he was involved? Yeah. Not other than us arguing in the class. Okay. Yeah. And all right. I feel like the holes on Christian holes. Right. Although easy fun and input, trying to pressure. Yeah. I was listening when you were listening to your friends. Are you friends with the guy by the name of Jeremy? We're acquaintances. And by Jeremy, I'm talking about Jeremy, Goodale? Yeah. We grew up together and went to the same school. How close are you? I think because we're both strong, confident, good at arguing. So when we get along, we really go on. And we know we really don't. So we kind of stay on, surface. He did. Okay, cool. When was the last time you saw him? School. Yesterday? Okay. Usually sit at the same lunch table with people. Pretty big. Okay. How are you doing yesterday? I mean, you guys on the ball again or off again? Oh, I didn't do ball. Didn't rock much, but yeah. I know Duke was kind of focusing on that Tuesday night when you would go on to your mom's office and you walked to your house. Yeah, okay, it's just 5 months. Yeah. During that span from when you left school with your mom and they went to bed, you were trespassing doing it? I don't think so. Like not on the walk or not going for a skateboard or anything like that? No, I really was in the area. I don't know see me. Okay. And you never, again, we just want to do something with the now, so. Sure. But yeah, there wasn't a time when you said, like, oh yeah, let's go skateboard, let's go do whatever real quick on that particular night. And do more. I don't know my phone, so. Right. But I mean, you could communicate with your mom's office, which is the only thing, right? We could. But, no. You know what you did? No, he didn't skateboard. No. Oh, okay. He was still, no, I was getting home, he was about a block from me, press arm, so. Do you check quick or? Also small talk. Yeah, okay. And then, what was the small talk? I don't remember. So, one of the areas that we're really looking into, and you talked about Ms. Graber's routines, right? Mm-hmm. And so when talking to a lot of people, we figure out what her routines are, right? Okay. And so, one of the areas that we're really focusing on is where she would go on her routine walks when she got done with school out of that. Maybe you can help me with the pronunciation. That's exactly right, for Tuesday night. Is there any reason why somebody might have put you out at Chicago? I looked like other people, and I was wearing a black hoodie, I think that thing. Sweat, I don't know. Yeah, okay. And tell me about the situation that you described. And remember, and before you get started, just kind of remember what I just said about 10 minutes or so. Okay. I have heard prior things for the past week about just a lot of people talking about Miss Graber, and just, I knew something, I read that there were people at the park posted up, I don't know, on the trail or what, and I had seen some teenagers who were coming like in the distance of Carol. It was sketchy past here, and I think something might come out. I need to disassociate myself because I'm staying on the right track. I need to keep clean record. I'm getting all my praise. I'm getting myself credited. I'm not going to prop myself by becoming a suspect because of me being fine, something that just happened, and being a teenager. And so
you say you didn't do anything. Okay, version 1, version 2. Let's go with the last version. The last truthful version of this. Okay? I'm not welcoming. I'm not 100% honest with you. Okay, like I said, a lot of people working on it. I can tell you right that you have regret. Okay? But lying and falsehood and half-truths don't show a person who's remorse about what they did.
We were walking down the path, the road, and there were people. Okay? I'm telling you, this is not a one-person thing. There were 5, 6, 7, okay? And I'm walking down, and then there's a picture that I had off, and there's a bench, and I sat and I said, you made me really. Because there's, I think, you have something good in hands. So I shook them off, we kept walking, and then 3 minutes later, I looked down, and I could see there were multiple people around, and they were moving like a body. Okay? And I freaked out. I had a panic attack, and I ran.
How many of you are talking?
There were 8 or like 8, I would say.
8 people. Just 8 people. Just 8 people. Okay. I imagine through previous conversations with jury, you know what they think of the funeral.
I know.
And you know the jury's going to know it?
That
you don't know anybody else involved in your decision trial? You know what somebody in these things are, right?
There's honesty.
What do you think?
I don't know any straight up that confirmed because after the event, there was no information disclosed. Nobody was wanting to do anything. All I know is that all I can know is people that were discussing it beforehand or just
let's talk about who was discussing it beforehand.
School. I heard.
When did people actually talk about what the plan once they got Did you hear, did you hear anything from anybody indicating that the plan was to actually knock her out as opposed to something else? And what was that? What was that plan about?
All I heard was, oh, we knock her out with the girl, with the road defense.
I see. You knocked her out, and then in stage like suicide, makes you got run on the tracks, or when you get run on the track? Sure. Okay. And you mentioned finish the job. Finish the job, are you referring to moving on the tracks, or?
Because, I'm saying that even if it's on the track, you're not gonna.
You don't have so much time.
Exactly. So that's what I'm saying. They probably demobilize her pretty quickly that even though nobody was around, draw her off, and then do whatever they need to do.
Okay.
In order to not be seen.
And then she starts walking. Does he start to follow her?
No, he didn't start to follow her. I did.
You started to follow her?
Yes, because I said something about me. So I went, I was walking in. I wasn't sure who was walking down. So she honestly got walking. And then I was waiting there. Saw that I had a head attack. I felt in an adrenaline leg issue when you just really face it. You washed. My hands were all sweaty and I kept trembling. And
what were you planning on doing that follow her?
I followed her to the associate myself. No, I wasn't stopping or following her.
No, I mean, disassociate yourself. Shouldn't you have gone in the opposite direction?
Yeah.
And you said you saw a group, 6 to 8 people wearing masks, carrying her.
They were carrying.
Right?
Yeah, there was a and they were moving.
Okay.
And the thing is, change all the message to things that the movie on here. I didn't see a 6'2" person unless it was on shoulder and then in the back.
So you can go to the lookout or something? Or the coordinator of it?
I'll look out for the reasonable to say because
our crime scene team is already out there, digging through leaves and picking up what we see with evidence. The vehicle's impounded, so we're going to be going through that. So is there any chance, because the last time that I won is for 2 weeks, we got to get a lab report, DNA located at the scene, in the car, the van, or anything like that comes back to you?
you don't think it would be possible for me to run off on Jerry?
No.
How so?
No. Transfer DNA doesn't work like that in the elements.
I could mark it on him. I'm saying it's something I think is possible.
Is there any chance that your DNA can be closer to the scene than what you just described?
Maybe like a new girl.
Maybe you do a girl.
Don't have 3 years.
And how did that happen?
Because they needed a new girl.
How did it work with me? Like I said, you were going to bump into you. Okay, you're way up there. You're closer there. You said, you said, right? Closer on. Closer on. I don't know. They're on the scene.
I'm telling you though that if I were to wear gloves and be that involved and was involved in the process of moving her, I would not wear gloves.
You make a mistake.
Sure.
You said that didn't happen, right?
I was not inclined to know how that, but I didn't,
again, sitting down with Jeremy, or sitting down with Jeremy and his twins, with the girls, nobody's going to put a weapon in your hand. And nobody's going to put you right in the middle of things. And so, and be like, hell yeah, not only that, but again, he was there to help move the body, scared or not, he helped move the body. What about the car? The man. Were you ever in their car? 3 weeks ago. 3 weeks ago you were in their car. You moved out this weekend. she's in the car with you that time?
Yeah, she was there. She was in the driving because her car was like there.
And you've been in that car the last 40 hours? You know that?
Yeah.
So where you are from that? Did you help with it? Did you help with it, or do you live there, or how you got all that? Whether it's against your will or... Yeah. Okay. Did you drive? No. You didn't drive? You were in the passenger seat?
I was in the car. Pushed it.
Pushed it down, yeah. Pushed it off. So where it landed?
Yeah.
You were in the reverse seat? You were in the driver's seat? So stand up, who's that not go to the park at this date? Who told you to go?
Jeremy.
Okay, so Jeremy sent it out.
He contacted me for them, but I don't think it was so idea.
And why don't you think it was so late?
It's my Jeremy, I always do it. I don't actually kill this girl. And I was telling class, but I'm not going to teacher, but I'm telling the class. And I got a board and I said, I don't hear about that. I don't know how to score that.
So it came up there with 2 other girls. Maybe Chase was there. And Trace was there, you said. Chase was maybe getting to bring her. Is that for sure there? No. So that's maybe Keith maybe, or Keith for sure.
I'm very positive, very positive.
That Keith was there. And
Because I'm around a lot, I recognize that I did talk against this very decision, yes. And pay lenders.
so Jimmy's for sure there. Hayden's for sure there. Then maybe Keith very positive. Chase maybe. Part of the plan is Keith or Kenny of the plan. Ben has and Chase is all part of the plan.
Special Kedley, during the course of your investigation, was there any record or evidence whatsoever as to any of the individuals listed by the defendant being involved in killing Mrs. Graber besides Jeremy Goodale?
So my role in this investigation was somewhat limited to those opening few days, and Case Agent Valletta would be the person to specifically discuss whether any other information was reviewed indicative of other parties being responsible. Me personally, I am not aware of any other additional information that came about indicating others were responsible.
Thank you. This time is probably a decent time to pause for lunch at the court's attention.
Yeah, we can take our lunch break now. And counsel, if I gave you guys maybe restart back up at 1, is that acceptable?
Sure.
Your Honor, I would ask if we have until 1:15.
That's fine. We'll be tomorrow if we don't keep the train on the track. So we can maybe everybody try to get back there at 1 and start as soon after 1 as possible. We'll take our 1 recess.
We're back. After our lunch break, Mr. Moling, you were asking this Agent Kedley if you want to continue.
Hey, Your Honor. Afternoon, Agent Kedley. Left off, we just finished reviewing your interview with the defendant in November of 2020. I'd like to, if we don't mind, excerpts of 1 to 9, which is in the record. Special Agent Kedley had the opportunity to interview Mr. Miller, Goodale, at some point here.
I did, yes.
Could you walk us through the facts and circumstances of the opportunity to interview Mr. Goodale?
So, as I said earlier in my testimony, in this investigation was relative to a few interviews that were conducted in the early stages, to include that of Willard Chaiden Miller. After the initial week or so of the investigation, away and was obligated to other duties within my area of responsibility. In 2023, I was conducting prosecution in this particular case and advised Jeremy Goodale had agreed in principle to sit for a interview, and given the fact that I had conducted of Mr. Miller and knowledge about the case at that point, I was able to conduct a proper interview with Mr. to do so with Lieutenant the Fairfield Police Department also sitting in.
We have a freeze frame from a video image.
I do, yes.
And in addition to and Officer Kinsella, who are the individuals?
Yes, so sitting me wearing all orange, Jeremy Goodale. To the left is one member of his council, followed by another member of his council.
Okay. And so Goodale was audio and video recorded?
It was, yes.
To get into the conversation place.
This interview took inside an interview room at the sheriff's office near where Mr. Goodale.
Mr. Goodale, at the time of this video.
That's correct, yes.
I will play your interview with Mr. Goodale, and they have a couple of questions afterwards.
We're having a conversation about Ms. Graber, and not necessarily about a conversation with him about, some frustration.
Probably would have been a month and a half before he brought up some frustrations to me about how he was having a hard time. He didn't feel like very adequate understanding.
Okay. Early in the school year? Okay. Before November 2nd, we put us in like, is that around or about that time? So that he had disclosed to you some frustration style or grading, or what were some of the specific issues that he was?
He just felt like she was very old school. He said he felt like and that she had it out for him.
Was it apparent right away when he first started talking to you in mid-September? Was it apparent right away he's really, really upset, like this guy is really, or did that come later?
Be apparent. Okay. And it didn't really be apparent until before this happened. It kind of came up suddenly.
Was he talking about it frequently leading up to that, or
like every other weekend, you might talk about time in Spanish.
okay? And you said before November 2nd, all of a sudden. Okay, tell me about that.
Well, like the other day, I was eating lunch in the cafeteria, and Chaiden and a few other people that we said, and I got up to face, kind of pulled me aside. If I killed his career.
Truman makes this comment to you?
Yeah.
Okay. People, or are you still part of a group of people that's very talented?
We were standing up, sitting, or you're directly adjacent to anyone. We immediately whispered it to me.
I killed Miss Graber? Those are his words? Okay.
I paused for a moment, and I said, sure.
Okay. And, I mean, that's not a friend asks you every day. And the reaction of like, hey, I'm here to help, or what kind of thoughts are going through? Yeah, sure.
I mean, it was just trying to get out. As soon as I was like, holy shit, man. I'm just trying to be a good friend.
Genuine and sincere, or did you think he was
Still makes work he was serious or not.
what's the next thing that happens, whether it's planning, communication, surveillance, what happens next?
It would have been about a week later.
An hour, a week before the incident itself. Okay.
Correct. He just made a passing comment about there's a 4-day weekend coming up, and he said it'd probably be a good time to do it.
And what was your response to that?
I said, okay. I mean, shoot the plan.
And I mean, you're a smart kid. You're a socially functional kid. Makes friends here, makes friends out there on the tennis team. Did you feel like, in spite of the fact that there could potentially be some bad consequences, legal consequences for being involved in something like that, you were close enough to Chaiden that it was worth it?
I'll be honest, the consequences never crossed my mind.
Okay. What were the effects of him not doing well in Spanish?
He had expressed a desire to me to go to boarding school in Spain, possibly for his, to add to the college resume to make him look like a more appealing candidate. And he was very sure that it would be possible if he failed a class like Spanish.
Were you aware of him having beef with anybody else besides Ms. Graber?
He had a problem with a couple of kids. Aaron, I can't remember his name. It would have been Keegan. It's been a long time since I've got one of those. Yeah, I think they jacked a couple things off him, and I went on my own accord to kind of ask him what that was about, but I mean, he didn't ask me to do that.
Mm-hmm.
I don't know if anyone else that he currently had problems with at the time.
Mm-hmm. Okay. And what type of equipment did you use? Obviously, the baseball bat. What type of other equipment did you use? Stage out there or bring with you that day?
I wrote on myself. I put it in the glove with the cat. Chaiden, I guess, had a backpack filled with a bag of water, a screwdriver, and a hammer, all to destroy her phone if we found it on her person.
Okay.
He also brought the bat itself.
What's the water for?
Not to destroy the phone.
Okay. Water, screwdriver, and hammer to destroy her phone.
He also brought a pocket knife, and he said, well, just in case we need to use it.
Presumably to stab her? Okay. And let's talk about, in the lead up, surveillance. What kind of surveillance are you guys doing?
So it would have been on Monday, November 1st. I would have been hanging out with John and Braden, I believe his name was. I was more of an acquaintance with Braden.
Mm-hmm.
Introduced through John, but I would have been hanging out with John and Braden at the skate park.
Mm-hmm.
And then I checked my phone, and I remember I was supposed to go do this surveillance with Chaiden. He came out, and I guess he said she had some other stuff she had to finish before she would leave. And so he went over to the bike rack, which was farther away from where her van was. At the time, I didn't know what car she drove.
Mm-hmm.
And he goes and he leaves and gets on his bike, and I'm still standing near the football field, actually, coincidentally, a few feet away from her van.
Mm-hmm.
And I begin to walk my bike up over to see what's going on with Chaiden. And that's when I see her come out of the school and get to the van. And then I followed it to Chicago on bike. We watched her walk the trail once around, and then we just left.
Okay. And where are you watching her from?
On the trail itself.
You're on the trail? Mm-hmm. Are you 50 yards behind her? Are you walking her bikes along the trail? Okay, distance. Does she look back and do anything of that nature? No. So as far as you can tell, you guys didn't make eye contact. She's not aware that you're back there?
I can't remember if it was the day of or if it had been on Monday, but we did end up bumping into her and saying hi. I'm not exactly sure whether that was that day or the day of, but yeah.
Okay. Going into it, before you go there, before it actually starts happening, in your words, what's the plan?
Hit her with a bat and drag her off the trail.
Okay.
You had it already picked out?
He had that already picked out. And I found out when he dragged me off after I said goodbye to Zoe, and I followed him to where he already had all his equipment laid out.
Okay. And was that equipment what we just described before? Okay. And you had it laid out already? Mm-hmm. Okay. What kind of things is he saying? Is he saying, like, I'm gonna fucking kill that bitch? Is he not saying anything? Is he describing to you what you two are going to do? I mean, it's pretty easy and straightforward to say, we're going to hit her, we're going to drag her off, but I imagine that there was a little bit more color in the conversation.
I discussed how, or he said he would just walk up behind her and hit her, and I said, well, okay, I guess I can stand a little farther up the trail and look out and make sure no one's coming from this direction.
Okay. Like in front of where she's walking?
Yeah.
Okay.
And you said you had equipment laid out. What equipment is he looking at?
It would have been the screwdriver, hammer, baseball bat, water, pocket knife.
And then you instructed to bring the equipment yourself?
No.
Okay. And then so the plan is he's going to hit her in the head, you're going to stand watch out, and then you're going to together remove her from the trail. What's the plan after that?
There wasn't really a plan beyond that. It's just improvisation.
Okay. Like hide the body, bury the body, stage the body?
At that time we were going to hide the body and had come up that we could try and make it look like it was a suicide of some sort laid on the tracks. That just didn't seem right. It didn't seem like it would work here. So after we had, after he had hit her, I told him, like, holy shit, like, make sure you got it, like, make sure it's done. So then he hit her a couple more times, and then he dragged her off. Pretty sure I did that by myself. I dragged her off. He was looking along the trail. He already put the bat back where he had it with the rest of his stuff. And then I dragged it back to pretty much where the equipment was at. And I heard something gurgling coming from East River, and I grabbed the bat, and that's when I made sure she didn't have to continue living in that state.
And so at this point, if you don't mind, one of the things that sometimes I like to do is just kind of open it up for an open narrative. And by that I mean, I'm going to try to shut up long enough for you just explain your recollection of things, how they went down. I'm sure I'll probably have some follow-up questions when you're through, but sometimes just kind of like putting it all on the table, and it gives us some perspective on what we're looking at. So if you wouldn't mind, just beginning, you're with Zoe, you're smoking weed, and at some point I assume change shows up. If you wouldn't mind taking it from there.
Sure. So I had just knocked Zoe's pipe off the table and broke it, and her vape had died. She was getting ready to go home, and I said, yeah, that's great. And that's when Chaiden came to the park, and I said, hold up. Then it was Chaiden. I think I had told her I was going to be eating at trail, so I got up and chased after him. Eventually I caught up to them. And then we walked back over towards where the access trail is. And then Chaiden we kept walking towards the access trail. I went over to Zoe, and I said, like, someone over the pay, you should probably go. It's nice seeing you. Bye. And she left, and I went down to the access trail where Chaiden was at. That's when I saw all the things he brought. And we discussed a general plan of like I'll stand up here, look out, walk up behind her, and then I think we walked back out onto the trail to wait for Miss Graber to show up. Can't remember if we saw her drive in or if we noticed her van and then knew she was there, but eventually she was there, and we bumped into her on the trail while we were looking for her. Said, "Oh, hi, how are you?" And then we kept walking back down towards the access trail. We were kind of in front of we were closer to the parking lot, so we took the quicker way to the access trail while she was walking around. And we waited there, maybe look out, and him standing on the access trail with the bat in his hands. And he kind of gave me like a nod saying, "Here she comes." And I gave him the signal that it's all clear, and then she walked by and he hit her in the back of the head, and then I said, like, "Holy shit, make sure she's dead." And so he hit her a couple more times, and then I dragged her off towards the access trail, and I wasn't sure whether she was alive or not, and I took the bat and I made sure that she wasn't alive or breathing. And then Chaiden wasn't there at that moment. He was standing out on the trail, I guess making sure that nobody else was coming along. And then eventually he did come back there, and I think he said, like, "What was that? Was that noise? Did you hit her again?" I said, "Yeah, I did." And then we grabbed her and we moved her towards like a strip of woods that separates the path from the access trail. And that's where we left her. Found her car keys, I handed them to Chaiden. We didn't find her phone. So the bag of water was like leaking, and I'm bringing it to the car. And so I took the bag of water. I walked to the end of the parking lot and threw it down a storm drain. And then Chaiden got into the van and came by and picked me up, and I jumped into the van and we drove off to a spot I knew about where I figured it might take a while before anyone found the van. It took me the end of middle Alaska. And then he drove the van behind the trees where it's found. So I snuck out of my house. He left his wheelbarrow in his driveway. pretty ungrateful for him. And I just grabbed the wheelbarrow. I think I had a shovel with me, put that in there, threw the tarp in there, and then I pushed the wheelbarrow down in front of the high school to Chicago Park. And when I got there, Chaiden was already there, and he was using a flashlight to scrub the blood that was left on the trail from where we had hit her, dragged her. Kedley kind of just worked from where he originally hit her down to the access trail. Just using lights to kind of wash away and wipe away any blood that we found, and pick up any blood leaves, trying to disguise any trail we left. And then we found Miss Graber's body. We moved it into the wheelbarrow and then rolled it along to where we eventually decided we moved far enough, and we rolled it past the tracks and placed the tarp over her body. The wheelbarrow was kind of falling apart, and it had blood on it, so we, kind of tried to take the wheel off of it, so it looked like a piece of trash, and we left it on top of the tarp. And then I went home. Actually, I walked to Chaiden's house with him, and he grabbed a pack of Alka seltzer out of his, grabbed that, and we went to my house, and we proceeded to get drunk, and then he left and went home, and I passed out in my bed. Yeah, that would have been. Yeah. And the next day, Wednesday, there was school. Went to school pretty tired.
Special Agent Kedley said a edited but fair and accurate representation of the interview that you conducted with Mr. Goodale, Co-defendant, Mr. Miller?
Yes, it is.
Roughly, if you can recall, about how long did you speak with Mr. Goodale?
I believe it was over 2 hours in total, but again, this was a summary of some of the major highlights, I would say.
And to the extent that, I know this isn't your case, but to the extent of your involvement, did the recitation of facts that Mr. Goodale presented to you correspond with what you already knew coming into this case?
To the extent that I was involved in the case, yes.
Thank you. Sorry, I have no further questions.
Cross-examination.
Agent Kedley, that was proper as part of a plea deal, is that correct?
I believe it preceded any sort of plea deal, but I believe that subsequently there was a plea deal in place, yes.
And part of what you're looking at was whether or not a plea deal could be formed based on Mr. Goodale's agreement to testify against Willard Miller.
Well, to be clear, that's not my responsibility in making those types of decisions. Ultimately, those decisions are made by the state. My role is to only conduct the interview.
But you were aware that you were looking for information that Mr. Goodale could give against Willard Miller?
Potentially. Ultimately, we were just looking for what his account was, and how that account would be used down the road was not my role.
Certainly you were aware, though, that there is the potential to testify against a co-defendant?
Certainly the potential, yes.
I have no further questions.
Mr. Mullen?
No further questions, Your Honor.
Thank you, Agent Kedley. You can step down. State having one more witness, is that right?
It does, Your Honor.
Go ahead.
State calls Fairfield Police Lieutenant Julie Kinsella.
Do you promise or affirm to tell the truth, the whole truth, and nothing but the truth? Please have a seat.
Afternoon, Lieutenant. There's a button at the bottom of your mic stand. Thank you. For the benefit of the court reporter, would you mind stating and spelling your name?
Julie, J-U-L-I-E, Kinsella, K-I-N-S-E-L-L-A.
And how are you presently employed?
I'm a police officer for the city of Fairfield.
How long have you been with the city of Fairfield, Lieutenant?
The beginning of October, only 29 years.
Pretty familiar with the town of Fairfield after 29 years of patrolling it, I imagine.
Yes.
I'm going to jump right into it. You were in the room with when Special Agent Willard was testifying about all the details of the investigation in this case, correct?
Yes.
How did Fairfield Police Department become aware that Mrs. Graber was missing?
Paul Graber reported his wife missing about 8:30 on November 3rd. Shortly after Paul reported his wife missing, we got a call from the school that said that Nohema Graber had not shown up for work. It was very out of character for her. She had never been a no-show, no-call prior to that time.
You mentioned Paul Graber. Is it fair to state that when a significant other goes missing that you might look at the male party first just to clear them?
Yes.
Was Paul cleared in the missing or disappearance or death of Mrs. Graber?
Yes.
How was that process undertaken?
We did several interviews with Paul Graber. We subsequently got a search warrant of the Graber residence. And then we started corroborating things with the school, what was told to us by the school. And everything that Paul Graber had told us was accurate that we could prove.
At a certain point, the report of Mrs. Graber being missing transitioned into a homicide investigation. How did that transition?
I want to go back. Once we listed her as a missing person, we did a media release. So then we started getting information and at times that people had seen Nohema Graber prior to us. We decided, since the last place that we saw Nohema Graber was at Chautauqua Park, we couldn't locate her vehicle at that point, we couldn't locate her, that we were going to start with the park, do a grid search of the park, and then go from there.
Was a grid search of the park conducted?
Yes, it was.
And what were the results?
Nohema Graber's body was found where it's been previously stated.
I'm having a little bit of trouble hearing you. Could you scoot the mic a little bit? Perfect. You're familiar with the defendant, Chaiden Miller?
I am now, yes.
How long did it take between the finding of Mrs. Graber's body and the defendant being taken into custody?
Approximately 10 hours.
During the course of this case, were you able to develop a theory as to the motive as to why Chaiden Miller would want Mrs. Graber dead?
Yeah, Chaiden Miller needed a passing Spanish grade in order to get his study abroad program that he wanted.
You wanted to go to Spain?
Yes.
Hard to go to Spain if you don't pass Spanish. In your conversations with other people around, were there other students that Mr. Miller expressed his disdain or anger towards Mrs. Graber to?
Yes.
Who were they?
Zach Askar was one of the people.
What did he tell Mr. Askar?
He said that he was angry, didn't like how Miss Graber taught the class, and that one day he hoped that she would be dead.
Anybody else?
Dill Hurlin.
What was told to Mr. Hurlin?
Same thing that's been previously stated. If she shows up missing, don't go to the police.
Anybody else? And that might be it.
That might be, I think that's it that I recall.
Did the defendant brag or boast after the death of Mrs. Graber to any of the students?
Calvin Sissifane.
What did he brag to Mr. Sissifane?
I caught a body with a bat.
Were you present in the interview room with Mr. Goodale along with Special Agent Kedley and others where he disclosed his part in the homicide?
Yes.
And you heard his disclosure about the order of striking Mrs. Graber?
Yes.
Was Mr. Goodale's version of events corroborated by any other evidence that you discovered in this case?
Obviously, the Snapchat messages, both to two of his gaming buddies, the Snapchat messages to John Burnett.
And how specifically did that corroborate?
What he told the gaming buddies was that he was involved with Chaiden in the murder of Mrs. Graber. Chaiden had hit her over the head, she fell over, and that basically he finished her off.
And that gaming buddy is Mr. Awesome Dude?
Mr. Awesome Dude.
And that's a Snapchat handle?
Yes, his real name is Jack Roll.
I believe Special Agent Willard testified to the prep list or the notes items. Were you aware, or did you see the notes app evidence that was presented earlier?
Yes.
In your investigation of this case, were wet wipes found at the scene?
Yes.
And were wet wipes on that note?
Yes.
Ziploc bag?
Pardon me?
A Ziploc bag, was that involved?
Yes.
Backpack?
Yes.
Hammer?
Yes.
Did you review the emails contained on the defendant's school email system?
Yes.
When reviewing those emails, were there any relevant communications where he discussed frustration, anger, or his opinion of Mrs. Graber?
Yes.
Could you give us some of the context of those?
At one point, Chaiden Miller missed a couple days of school. He was out on a vacation. He came back. He said that he was supposed to take a makeup test the same day. Other students were taking an additional test. He said when he got there that day that he was required not only to take the makeup test, but also the test that was given to the other students that day. He basically walked out of the classroom and went down and reported this incident to the principal.
Anything else in his emails that were indicative of his state of mind in this period?
He told his mother that he was very close to losing it.
Did he indicate that he was crying?
Yes.
Mrs. Graber made him cry.
Yes.
I'm sorry, I didn't hear that question.
Mrs. Graber had made him cry. Your Honor, I'm showing defense counsel pages 22 and 23 of the pre-sentence investigative report. Showing the witness, pages 22 and 23 of the pre-sentence investigative report. Lieutenant Kinsella, are you familiar with that document?
Yes, I am.
Your Honor, may I interject an objection?
Yes.
Your Honor, anything contained with this would have been protected information. Everything within that appears to be information for counsel or for a private investigator.
Your Honor, this is a sentencing, so pre-sentence investigative report is relevant for the court's consideration.
And you're on page 22?
22 and 23.
And is this a document that Officer Kinsella would have had access to previously?
Lieutenant, have you been provided that in 2021?
Yes, it was.
Okay, so the reason that I think you have a solid objection, but if she has already seen the documents, then...
Your Honor, they're protected two ways. I think you're talking about as a pre-sentence investigation, but also this was client communication to an investigator or to an attorney potentially that was intercepted, but it's still a protected document.
I guess, Mr. Molden, or to the objection, I will sustain it to the extent that any part of the PSI that this witness does not have access to, that she should not have access to, but to any document that she has previously had access to, she may testify to her knowledge of that document.
Thank you, Your Honor.
Your Honor, what I'm stating is that the document was written by Mr. Miller to be provided to his counsel. That it is a protected document, or in this case, to an investigator for counsel.
Your Honor, for the court's information, that information was provided to law enforcement, and it was of grave concern to the state to the extent that the subject of that document, Mr. Burnett, had to leave the state out of fear of concerns for his own safety.
Your Honor, may it be heard response?
Yeah, go ahead.
We can disclose. It's a description of a witness, where that witness lives, and who that witness is. But that, jumping to the conclusion that it was some type of, that it was going to be delivered to anyone other than counsel or an investigator is taking a real leap by the state. It's simply a description of a witness.
Isn't Officer Kinsella an investigator?
Well, it was written by my client for a private investigator.
Your Honor, I only intend to ask the lieutenant what action was taken after she was provided with this document.
Your Honor.
I guess, counsel, I don't understand the reason we're talking about this at all. So, I don't think it's improper to discuss something that this witness has had knowledge of previously. However she obtained that knowledge, she has this knowledge. I don't know if she has a copy of the PSI right now or not.
She's holding that page right now.
I guess, Mr. Molding, the easiest thing to do is to take it back and to ask her about her knowledge of the note. So to that extent that satisfies the objection, it's sustained, but this witness may testify to the knowledge she has based on her investigation.
Lieutenant Kinsella, the document and the attached handwritten note were provided to you.
Yes.
Is it fair to state that this handwritten document describes a critical state's witness?
Yes, it does.
John Burnett?
Yes.
I'm going to read the note out loud, and if you would affirm that this is the same note. John Burnett, 6'1", curly hair, blue eyes, white, always fucking wearing jeans, walks a little funny, swings his hands. Old paint-chipped white pickup with metal lockbox in the bed. Doesn't look like any other truck there. Fairfield Public High School starts at 8:10, ends at 3:30. He usually comes out of second entrance. Always parks on the left strip instead of main lot, all the way at the end, closest to the school and second entrance. Is that what you recall?
Yes.
When you received this document, did you have a meeting with Mr. Burnett?
Yes, we did.
And what was the context and reason for that meeting?
We were concerned for his safety.
Why?
Because that was a vehicle he drove, that was a description of him, and he was, at that time, the very key witness in this case.
Were you concerned for Mr. Burnett's safety?
Absolutely.
What did Mr. Burnett do after that meeting?
Objection as to relevance.
Overruled.
What did Mr. Burnett do after you had a meeting with him?
He went out of state and stayed with relatives for over a month.
Thank you. Lieutenant Kinsella, let's talk about the impact on the community of Mrs. Graber's murder for a moment. In the immediate aftermath of her death, what actions were taken by Fairfield Police and the Fairfield community at large in the days after her death that impacted the community?
I think we started with, before we actually located Nohema Graber's body, everybody, when we went public with the missing person reports, the media got involved. Everybody in Southeast Iowa knew that Nohema Graber was missing. Everybody was spun up. Everybody was concerned. Everybody was looking for her. Once we found her body and we did the media release that Mrs. Graber's body had been recovered, we had students that were scared to death to attend class. We had teachers that didn't want to teach for the concerns of their own safety. It was such a concern to the point where the schools shut down the schools. They obtained counselors, I think for 2.5 days, that they got out early, and then for like 2.5 days, there was no school. And then when the kids came back to school and teachers came back to school, there were counselors for both the teachers and the staff for the school. In addition to that, we had, as a community as a whole, we have stakeholders. We're a small community. We have key personnel, whether it's for the hospital, other healthcare providers, whether it's the hospital, mental health awareness, any place that anybody goes, such as the well, to get services or ask for help. We made sure that everybody had a complete list of mental health providers, of various services that we thought that anybody else would need in the community to take care of the well-being of our community. I think that obviously it destroyed Chaiden's family, this incident. It's destroyed Jeremy's family. It's destroyed Nohema's family. It has destroyed, our community is considered safe. We're kinder, we're gentler. That's the gist of our community. That's what we take pride in. And I think this incident shattered that belief for a lot of people. It took their safety, their well-being of the general public, and just stripped it of everybody, from everybody as a result of this. You know, we're still continuing to have school safety meetings to upgrade the safety protocols in the schools. Some of that came because of the school shootings nationally, and we got funding for it. But the other parts of this, making sure all the schools were aware of critical incident responses, how the police were going to go, where everybody was going to go, just so that everybody was on the same sheet of music. We continue to do those things. We still have meetings today with the safety, well-being. Every time that we've had a court proceeding, we make sure that there are safe falls in place for our community so that we can take care of the community as a whole and their well-being.
Thank you, Lieutenant. Just one more thing I want to ask you about here. Chaiden was arrested and his cell phone was taken from him, right?
Yes.
At a certain point, his cell phone was returned to his family?
Yes.
Was there an incident after Chaiden Miller was arrested where his snap map was activated?
Yes.
Could you tell us about the impact of that?
When the phone activated, it showed that Chaiden Miller was at his residence. We had numerous students, various people from the community calling us and asking whether Chaiden Miller had been released from jail.
People thought he got out?
Yes, people thought he got out.
What was the general tenor of their concern?
Concern for their own safety.
Lieutenant Costello, how has the death of Mrs. Graber changed their system?
I don't think that our community will ever be the same again. I think it's devastated us.
I don't have any further questions.
Cross-examination.
At the time of arrest in November of 2021, Jeremy Goodale was taller than Chaiden Miller?
Yes.
Heavier?
Yes.
A grade ahead?
Yes.
A more accomplished athlete?
Yes.
And more popular?
Yes.
And through your investigation, you did confirm that Chaiden Miller had a meeting about his grades with Ms. Graber?
Yes.
That he had done a substantial amount of homework recently?
The emails that I saw was that he was committed to getting his homework done, and at times he'd spent several hours with both a tutor and trying to get his missing assignments completed. Whether they were completed or not, I don't know that.
I have no further questions.
Despite all those things, Chaiden Miller, whether he's done his homework that night or not, planned and executed the murder of Mrs. Graber.
Yes.
Anything else for this witness, counsel?
No, Your Honor.
Thank you. You can step down. Anything else the state would like to offer, say, in a matter of sentence?
Judge, as I indicated, the four witnesses that we've called, that completes our presentation with regard to any evidence that relates to, that we have from the case from those witnesses that relates to the factors that we've mentioned before that the court has to consider in fashioning a sentence for the defendant. So we have impact statements later once the court gets to that, and our recommendation. I know the defense has several witnesses as well, but at this point we have no further witnesses to call.
And Ms. Branstad, witnesses on behalf of the defense.
One moment, Your Honor. Your Honor, the defense is offering no additional evidence.
Okay, then I'm going to go back to the state because I'm going to have the state make any further comments regarding what the recommendation for sentence is, and then I'll have the defendant or the defense counsel do the same. Then I'll give the defendant an opportunity to make a statement if he wishes to, and then we'll go on with the victim impact statement. Whenever you're ready.
Judge, as far as our recommendation, is that correct?
Yes.
All right, just briefly. The state is recommending that Willard Chaiden Miller be sentenced to a term of incarceration of life with parole with a minimum sentence to be imposed of 30 years. The reasons for that sentence, and the minimum in particular, are manyfold, actually, Judge. Most of those reasons have been on full display this morning whenever we put on our presentation with regard to the evidence that relates from Agent Valletta, Agent Kedley, Officer Kinsella, as well as Mike Henry from Oakdale. So I just want to focus on several of these factors that are listed in 902.1, 2B, 2A. First of all, the impact of the offense on the victims in this case, which is the Graber family, who is seated right behind me. The Grabers have suffered immensely in this case and at the hands of this defendant. I will tell the court that Paul Graber, Nohema's husband, passed away within the last few days. His funeral was yesterday. So not only does this family having to endure this particular sentencing hearing, they have now lost another important member of their family and a loved one, and certainly our condolences go out to that family at this time. But so the impact on them could not be greater. They will detail for you in victim impact statements later specifically what that is. I will tell you that in my experience as a prosecutor for 30 plus years, that the families and the people who know the victim are the best people to inform the court as to how that has impacted them and devastated their life. I will tell you that all of them, this is my characterization, I would say, are having to endure a new normal for them in the absence of Nohema and Paul Graber. So that the impact of the offense on each of these victims will be detailed. The other factors some of them I can lump together. The impact of the offense on the community was best articulated here by Officer Kinsella. The degree of the participation in the murder by the defendant, the nature of the offense, the heinous and brutal and cruel nature and manner of the murder are on full display in this sentencing hearing. This was a cruel, heinous act by two defendants, by not only Mr. Miller. I know that Mr. Goodale's sentencing is coming up later this year. But you look at this and it's like, what could be worse than what these two guys did? It is cruel to the nth degree. I cannot imagine anything really worse than to be attacked in the manner that she was for what? A grade. It's just beyond the pale, in my opinion. This defendant had, even though he's young, has full full capacity to understand what he did based upon the evidence that we have in this case. By many accounts in the PSI that I've read, the statement from his mother that I've reviewed, he had a lot more support in his life than a lot of other kids his age, and yet this is how he dealt with his problem. If this were something normal and usual, this would happen a lot more than it does. So based upon his history and that I've seen, the fact that he was relatively a good student in high school, it's, again, just beyond the pale that this was the way that he would have chosen to deal with his grade. There is evidence in this record that it was his idea, that it was planned, that he recruited Jeremy Goodale to help him. I will tell you that absent Willard Miller, based upon the evidence in this case, Nohema Graber is alive today. Jeremy Goodale, although he committed heinous acts against her as well, was recruited by the defendant. This was his idea. It was planned out. Everyone needs to get that. And it's because the evidence in this case is just simply overwhelming. He will have a chance at some point in his life, depending on the sentence that you give him. We're asking for a 30-year minimum here, but that gets him to about mid-40s before he's actually eligible for parole. The top part of the sentence is life. He could spend the rest of his life in prison, depending on how he behaves. And the nature and the makeup of the parole board, who knows what that's going to be, however many years down the road. But I will tell you that based upon the evidence in this case, based upon what we know about this case, what's been proven about this case, what you've heard from law enforcement about this case, and all the other evidence in this case, this defendant deserves every day he gets in prison, every single one. And he should get a 30-year minimum. That is what is warranted in this case, is what is justice in this case, and we ask that you impose a 30-year minimum with the top part of the sentence being life with the possibility of parole. Thank you.
I'll just start with the state. There'll be a requirement for the $150,000 restitution under 910(3)B joint and several with the other co-defendant. Regarding there is also some restitution requested for the Jefferson County Auditor and maybe crime victim assistance. And I've got a number of $3,099.13 to the Jefferson County Auditor and $16,299.06 to crime victim assistance.
Yeah. Judge, I'm sorry I didn't address that in my comments. I would agree on the restitution under 903B. Chauncey was just mentioning to me there may be some other amounts that you did not mention.
We had gotten a somewhat late filed crime victim restitution claim. So the state would just request 30 days for any additional and final tallies to come in on that prior to closing the record on restitution.
Okay, so you're requesting that I not order any other restitution other than the 910(3)B $150,000 until you have a chance to file a final pecuniary damage statement. Is that correct?
Well, there is the claims already in the record. I just believe that there is at least one additional one that may be claimed or filed within the next day or two.
Okay.
So we can leave that open or order what's in the PSR. But
I'll hold that open for 30 days. And then I'll get the defense's position on how they want me to address the restitution that's not required right now. With regard to the defense's recommendation on sentencing, Ms. Branstad.
Your Honor, I think the better part of today has been spent trying to show that Mr. Miller is guilty, and he is. He has provided a statement that is within the pre-sentence investigation where he goes through in great detail how he started out as dark jokes and a plan that just went forward. He admits providing the bat. He admits being a lookout. He admits participation. There is some disagreement about whether or not he had the bat and struck the first blow. And Your Honor, I think the evidence supports what Mr. Miller has said. There was no blood on him. There was blood on Mr. Goodale. And even the description within Mr. Goodale's statements was that he drug the body away and had the bat with him. Well, Mr. Miller stood lookout. Well, that doesn't make any sense unless he had the bat at first. You wouldn't take the bat from the person who had it if you also then had to carry something. That is just a small part of participation, but that may be our only factual disagreement. I think there was some discussion about the impact on the family and the community. We have no reason to disagree, but there has been no professional testimony, and most importantly, none with regard to the juvenile wild factors with regard to Mr. Miller. And that's where our disagreement is. We are asking that this court impose a sentence without a mandatory minimum and with the possibility for parole. And Your Honor, we're looking at the Lyle case at Roby, which is at 897 Northwest 2nd, 127, and which is a 2017 case, and then Majors, which is at 940 Northwest 2nd, 372, and that's a 2020 case. Each of those indicate that the burden is on the state to bring expert testimony and sentencing to support any request for a mandatory minimum sentence. Those are both very clear that a mandatory minimum for a juvenile should be rare, should be the exception, and needs to be supported by expert testimony. Those cases are very clear that the heinous nature of the crime does not does not put aside the need for expert testimony as to the juvenile factors. There is a statement made by the state that Mr. Miller has full capacity. That requires expert testimony. That is not something that is shown simply by showing intelligence. Intelligence and maturity are not the same, and maturation is the #1 factor looked at within each of these cases. In fact, the words are exceptional maturity. There just simply isn't that type of evidence. And in fact, when you look at the evidence talking about how this started and a grade, that exemplifies immature thinking. I think there's very clear evidence that Chaiden Miller was very wrapped up in thinking about his grades. In some ways, very normal. He had meetings. He was seeing a counselor about it. He had talked to his mother about it. He had said he was starting to lose it about the grade. He had a tutor. He was meeting with his teacher. He then took steps that were both juvenile and immature, and then criminal. Making dark jokes about, I could just kill the teacher. And I don't think there's any reason to believe that that's exactly what those were when he started at that point. That's how they were taken by his friends. That's what Willard Miller says it started as. And then something developed out of that. There's no doubt that Chaiden Miller has pled guilty. There's no doubt that he's guilty, but the question is, should he still have those juvenile factors in place. And to get past that, and I just can't emphasize that enough, there is no evidence in front of this court, and the state has not met the burden for a mandatory minimum. I'm looking at Roby, and it recognizes specifically that sentencing hearings for juveniles in adult court are not necessarily adversary. The goal is to craft a sentence in the best interest of the child. That the default rule is that a juvenile is not subject to minimum periods of incarceration. And that the seriousness of the criminal act is not such that is not enough to conclude a mandatory term is appropriate. Roby goes on to say a sentence without parole eligibility should be very uncommon. But again, it addresses those mandatories. Roby emphasizes the juvenile sentencing factors, and those are, of course, the Lyle factors, and that they must be used in determining any type of mandatory minimum. And again, Roby says that without expert testimony to support the mandatory minimums, each factor has to be analyzed in those contexts. As I stated, the 20...
Page are you on?
Your Honor, I'm looking at notes here.
Okay.
And these are my own notes. I might be able to find them. So, I think the exact words is within both Majors and within Roby is there is a presumption against a mandatory minimum for a juvenile. There's additional support in ZARATE, Z-A-R-A-T-E, which is at 908 Northwest 2nd, 801. And where the court found, and that's a 2018 case, a sentencing court with a predisposition for mandatory minimum sentences for a murder conviction may not use that predisposition, may not allow that predisposition to outweigh juvenile sentencing factors. And I'm trying not to repeat myself, but the cases somewhat repeat themselves. Majors states the importance of expert testimony for mandatory minimums, as stated in Roby, was directed at the state. And that was a case in which there was a question as to whether or not the defense had the burden to bring an expert. If the state wants to argue outside the presumption for no mandatory minimum, they have to apply the expert, the Lyle factors, and expert testimony is usually needed as a prerequisite to depart from normal sentencing presumptions against mandatory minimums. And, Your Honor, it is, Roby is at page 144, and that's requiring the defense to, Your Honor, the exact quote here for that one is, we reiterate that sentencing hearings need not be battled experts. Basic proposition regarding this process is that juvenile sentencing hearings are not entirely adversarial. The goal is to craft punishment that serves the best interests of the child and society, and it requires, and then again, Majors talks about that the defense is not required to present an expert, but I think that the implication there is that the state does have that burden There we go. The quote, "Our emphasis at Roby on the importance of presenting expert testimony on the Miller, Lyle, Roby factors was directed at the state. If the state wants to recommend that the sentencing court impose a mandatory minimum sentence, Roby held that an expert is normally necessary to analyze the factors." And that quotes, that's within Majors and quoting Roby at page 148. There were a number of pieces of evidence presented to show that Mr. Miller participated in a murder. He did. That he did not tell the truth when he was initially interviewed. He didn't. Much of that, though, shows some very juvenile behavior. His responses were that of a juvenile in many, many ways. And I want to emphasize, my client is now 6'4". He was, according to one of the police reports, 5'6", according to my client, 5'8", when he was arrested. He may look like an adult based on his height, but he was a 16-year-old. And his behaviors certainly show that of a 16-year-old.
Ms. Branson, I'm sorry I'm interrupting you, but I just want to make sure that I'm understanding your interpretation of State v. Majors.
Yes.
Because that was a case that was sent back to the district court for resentencing after a mandatory minimum was imposed. Then on remand, a district court judge resentenced the defendant to the same sentence for attempted murder. And then that was appealed. And the holding of the Iowa Supreme Court in State v. Majors was that imposition of a mandatory minimum sentence of 17 and 1/2 years was not an abuse of discretion, and trial court did not have the duty to present expert witness to testify regarding juvenile sentencing factors. Are you saying that that only applies to you as trial counsel? Or if that you're saying applies to the state still has to present expert testimony if they're asking for a mandatory minimum?
The state does still have to present expert testimony absent, well, that is the norm. But there's a difference. Yes. I mean, if it's the norm, or whether or not you think I am just prohibited from considering the mandatory minimum today because there hasn't been expert testimony. I don't think that's what the cases say. I think that it says unless there is something, I think it does say that within this case. That the burden is on the state, and that the Miller, Lyle, and Roby factors are, it's incumbent upon the state to show that those factors have been met. And in this case, I don't think there's been any evidence that would overcome the need for an expert. I think that the defense does not bear that same burden. And I think it stands for that proposition that the defense doesn't have that burden, but I don't think it takes that off of the state. And there has to be something specific to maturation, and specifically at least within the realm of what an expert would show. I don't think that becomes lay evidence based on that. From my reading of it, Majors doesn't take any burden off the state. It simply addresses the defense burden. And Your Honor, Roby is even more specific as to the burden on the state. And Roby remains good law as well. I think Majors becomes a little bit more confusing because it's dealing more with the defense burden, so you have to look a little bit more within the dicta of Majors. Your Honor?
Yeah.
As I'm reading it, and so the files in, the factors in Lyle are mitigating factors. None of those become exacerbating factors absent expert testimony. And Your Honor, if I look at, State v. Majors does say, our emphasis in Roby on the importance of presenting expert testimony on the Miller, Lyle, and Roby factors was directed at the state. If the state wants to recommend that the sentencing court impose a mandatory minimum sentence, Roby held that an expert is normally necessary to analyze the factors. So, I mean, it says normally necessary. It doesn't just say is the normal, it says it's normally necessary. And that is at me in State v. Majors at 392.
Anything else, Ms. Branstad, regarding defendant's recommendation of sentence?
Your Honor, and just because there was quite a bit of emphasis on Mr. Goodale's proper statement, going to the weight of that, there's pretty clear Iowa Supreme Court precedent that indicates a proffer is inherently unreliable. I have a number of cases, but State v. Brown, 397 Northwest 2nd, 689, State v. DeWitt, 286 Northwest 379, are clear that when a bargain is made for testimony, especially an accomplice's testimony, that the statement is tainted, unreliable, and is often inadmissible against a co-defendant. In this case, certainly we're at sentencing, there are different rules of evidence, but the weight of that evidence certainly we'd ask the court to give that no weight and to look instead at a statement made by Mr. Miller in his pre-sentence investigation and the corroborating physical evidence, as well as the recorded statements of Jeremy Goodale in the Snapchat that was provided to the court. That goes to one small factor here, Your Honor, but I do think it is a somewhat important factor to look at in this case. Mr. Miller's aware that he's looking at incarceration, but he is asking that this court not impose a mandatory minimum.
Thank you. We're going to take our afternoon recess at this time. Take 10 minutes.
All right.
Please be seated, everyone. We are back on the record after our afternoon break. I believe we just finished up with the defendant's recommendation. Is that correct, counsel?
Yes, Your Honor.
With respect,
Your Honor, I think your microphone is
it cut? Sorry. We had just finished with the defense counsel's request for sentence. Regarding restitution, I had asked Mr. Molding about ordering the current amount and then holding open for 30 days. What's the defense's position on that?
Your Honor, we agree that the $150,000 mandatory restitution can be imposed at this time and hold open the additional restitution.
And I guess, Mr. Molding, you okay with that?
Yes, sir.
Okay. Mr. Miller, you have the right to make a statement. It's called allocution. Is there anything you'd like to say to me before I sentence you?
Yes, Your Honor. I'd like to take this opportunity to wholeheartedly accept responsibility for the role that I've played in the murder of Nohema Graber. I would like to apologize for my actions, first and foremost, to the family. I'm sincerely sorry for the distress that I've caused you and the devastation I've caused your family. And from the bottom of my heart, I am sorry for your loss. I'm sorry to hear about Paul Graber. I would also like to apologize to the community, to just the ripple effect that my actions have had, everyone that is affected. I would like to apologize to Nohema Graber's church. I know that I know now that she was a very active member there and doing a lot of good things there. I'd like to apologize for what I did and how that affected them. I'd like to apologize to my family. I love you guys so much, and I'm really sorry for what I've done and how it's affected you. And I'm planning on getting back out there as soon as I can and make up for lost time. I'd also like to apologize to the Goodale family. I'm sorry for the position that Jeremy's in, and I wish you the best, and I hope that you get out as soon as possible. Sorry. I know what I did was wrong, and I accept responsibility for my carelessness, for my ignorance, and also I'd like to apologize to the police department and the investigators there for the misinformation I provided back in 2021, to lead them on a wild goose chase I ended up there. I'm sorry for that. Coming here today, now at the end of this stretched out journey, I'm realizing just the magnitude of my actions, and I know it's wrong, and I knew it was wrong, and yet I still carried through. I still did what I did, and I accept responsibility for that. And I apologize to all parties, everyone affected, to my community, to my family, to the Grabers, of course. And I ask that I'm given a chance, and I don't want to be institutionalized. I don't want to be in so long that I forget about what matters, where I come from, and what I need to do. I look forward to getting through this. Thank you.
Are there any, I know there are victim impact statements, and Mr. Brown or Mr. Molding, how do you want to get those started?
So we have 10 of them. Nohema came from a large and extended family. All of these 10 qualify. I believe they're either siblings, in-laws, or children. That's where they would all, I think, fit into those categories. So several of them are going to be read by Sarah Harms, who is the victim witness coordinator in my office. Others will be read personally, and there's at least one I know that another family member has been designated to read another family member's statement. So that's kind of generally how we'll approach this. The first up, there will be 2 that will be read by Ms. Harms, Marilyn Foos, and then Norbert Foos, who are in-laws, correct? Correct. So we'll start with Marilyn first, if that's okay. Please.
Whenever you're ready, Ms. Harms.
Thank you. The first statement I'm going to read is from Marilyn Foos, who is a sister-in-law to Nohema Graber. I do believe every person my sister-in-law Nohema Graber ever met became her friend, if she wasn't already. The only exceptions being the 2 who stole her from the thousands who loved her. She had a way of lighting up the room when she entered. That was because she genuinely cared about every person. People called Nohema an angel when they spoke of her. She had more than 50 godchildren, maybe 56, but she didn't broadcast the fact. Instead, she chose to live her love for them and anyone in need without thought of self. She never spoke of her good deeds, but lived the gospel every day with her big, joyful, loving heart. She was a private person in that way, not at all self-seeking, but her personality truly did make everyone feel lighter. When Nohema first joined the Graber family, English was tricky. It was hard to understand her speech unless you listened very carefully and patiently. It was difficult to hold a meaningful conversation for those early years, yet she did not give up. Nohema mastered the English language to the degree of becoming a full, competent, and indeed exceptional teacher. Her favorite classes surely were with the Spanish students, whom she amused and entranced with tales of her beloved Mexico, all the while teaching them to speak an important language and broaden their understanding of the world's potential for them, if only they would be diligent. Nohema loved people. She prayed earnestly for them. She treasured her faith and never gave up her love for God, but instead pressed into Him when troubles came. She helped so many, so often, so well. She knew how to love. Nohema's husband, my brother Paul, missed her so deeply. I am convinced that hastened his very recent death. We all missed her cheerful voice, her deep, throaty belly laugh when something was funny, the way she pursed her lips into an O when she was thinking about the word that was just right. She was a mercifully forgiving person who did not harbor ill will when wronged, but she did stand up for truth. She tried so hard to help people succeed, whether in their walk with God or in this life. She was an absolute blessing and an angel, for sure. The next statement I'm going to read is from Norbert Foos, who was Nohema's brother-in-law. Nohema Graber was a very special person that I have had the privilege to know in my lifetime. She was a caring, selfless individual who had the best for those who were struggling and needed care. St. Francis once said, "Preach the gospel at all times, and if necessary, use words. Nohema Graber was the best example of this by her love for her fellow man. After her death, we heard so many stories of her selfless giving with the care of the less fortunate. This was especially true in the Hispanic community who needed help and direction in living in Iowa. Nohema and her beloved church was that lighthouse of hope to those who were less privileged and needed a direction and help to succeed. Nohema's faith was strong, and this motivated her to care for others. What especially was impressive was her ability to teach others with passion. I have been associated with education for almost 30 years. Many teachers have been great educators, but not many educators have a passion for their students themselves. Nohema taught with excellence and with a caring attitude for the students themselves, becoming a person they could receive advice from. She knew that life in this world was not easy, and you need to work hard and diligently if you want to succeed. The death of Nohema has had a profound impact on her immediate family, and we believe that this contributed to the untimely death of her husband, Paul. But now we have a situation where three children who may someday be married and possibly have children without the ability of having these spouses or children know their parents. Plus, they will have to take care of one of their siblings who has special needs. I am confident you have heard what a special individual Nohema Graber was. The ability she had to live a life that God was proud of, and her selfless acts that is very hard to replace, especially for what she did for the Hispanic community in her area. It is a complete travesty to have two young people take the life of Nohema Graber deliberately and away from so many.
Judge, the next victim impact statement is Tom Graber, who was the brother-in-law of Nohema Graber.
This case has had an enormous impact on Nohema's family, Fairfield High School, and the Fairfield community at large. Not only was Nohema robbed of 30-some of the best years of her life, her murder deprived Paul Graber of the love of his life and certainly hastened Paul's own premature death. It has also had major impacts in the lives of their children, Christian, Jared, and Nohema Marie. In the spring of 2021, Paul had just endured more than 5 years of dialysis, a side effect of his severe diabetes, and received a miraculous kidney transplant. Things were at last looking up. Finally untethered from the dialysis machine, he was looking forward to resuming travel with Nohema and their son Jared, visiting eldest son Christian, who then lived in Spain, and Nohema Marie, who was working in Europe, and family and friends in Mexico. Instead, Willard Chaiden Miller ruthlessly murdered Nohema a few months later. Paul was deeply and understandably depressed by the murder of Nohema, and his life ended last week from the ravages of a metastatic cancer that would have been caught and treated far sooner had Nohema been there. I am certain, from knowing Nohema for more than 35 years, that she would have made Paul see the doctor much sooner for the new pains and skin lesions he'd begun experiencing late last year. She would not have let him ignore these symptoms, and she would have insisted he get them checked. Instead, depressed as he was over her murder, he delayed seeking treatment until the very end of March, and now is dead at the early age of 68. Proof of that depression and the impact of Nohema's murder can be seen in Paul's conduct. In January 2022, just 3 months after the murder, and again this May, my brothers Bill and John, neither of whom lives in Fairfield, almost forcibly had to take Paul to the hospital, to the emergency room at Jefferson County Health Center for acute care, without which he very likely would have died on each of those occasions. The first episode was COVID related. He was living at home he was lying at home with the disease, alone and without energy enough to even raise his cell phone to his ear to answer it. They became concerned and drove to Fairfield to check on him. The second episode involved a near-fatal spike in his potassium levels after essentially ceasing to eat or drink for days this past spring. I know of these both directly from being on the phone with Bill and John during them. As Paul told me March 31st, as we sat together at the University of Iowa hospitals, waiting several hours for his room to become available, he'd been having several vivid dreams recently in which he saw Nohema, who gave him signs he interpreted as telling him that his time was coming, that it was drawing near, but it was not yet his time to go to her. And she was on his mind a great deal, and he spoke of her often. Had Paul not been so depressed from the murder of Nohema, and had she been there to assist him, she would have helped him deal with the side effects of his cancer surgery, would have prepared irresistible meals she would have insisted he eat and drink. Even more importantly, had she been there, she would have insisted he seek care last year, when the cancer would have been far more easily treatable. She would have made certain he saw a doctor. Instead, without Nohema, no treatment was sought until too late. Willard Chaiden Miller's murder of Nohema played a very important role in the premature death of Paul Graber. The murder also deprived the family of its primary breadwinner. Paul had been disabled for more than 20 years due to extensive nerve damage to his feet and legs from the ravages of severe diabetes. Nohema stepped up, obtained a bachelor's degree from Iowa Wesleyan, and her teaching certificate, and became the family's primary source of income. Nohema's murder has been very difficult for their adult special needs son, Jared, who has a severe genetic disorder. He wanted to be here today, but was admitted Monday to the University of Iowa hospitals on an emergency basis. And Jared and his mother were particularly close and loved each other's company dearly, going to church every week and visiting family and friends in Mexico most summers, and occasionally to Europe, using funds that Nohema frugally saved from her salary as a school teacher. Willard Chaiden Miller put an end to that. The murder has also caused great change in the lives of their other children, Christian and Nohema Marie. Self-supporting adults both interrupted their lives to come home and help Paul in his illness and to help care for Jared. Christian this year has already taken more than 12 weeks unpaid leave from his job as an international medical courier in order to help his dad, and is in the midst of planning further changes to facilitate his taking over as guardian for his disabled younger brother, Jared. That had not been the original plan. No. Mother Nohema was the rock of the family. She was the primary caregiver for Jared. She was in very good health, had a long life ahead of her. Willard Chaiden Miller put an end to all that too. Indeed, not only had Nohema been a devoted wife and loving mother, putting herself through college in her 50s, she taught for several years in Ottumwa and was in her 10th year of teaching at Fairfield High School when struck down. There she's remembered by her many hundreds of students and their families who have embedded a large granite monument to her in the wall of the high school at the end of a hallway near her classroom. Established and funded scholarships in her name, held candlelight vigils in her memory, packed the high school auditorium at her evening prayer and vigil service, created beautiful works of art in her memory, and left flowers in a reserved auditorium seat at numerous student concerts and performances in her memory, and an appreciation of the support she had always given her students in their out-of-classroom endeavors. Area high schools also honored her, sending gifts and condolences to FHS, and wearing orange and black team uniforms at their own games in support of the grieving students and staff at rival FHS. Memorials were also placed at the public library and elsewhere in town, and permanent memorials at Chautauqua Park, as well as the school. The governor of the state of Iowa ordered all flags on state property flown at half-staff from dawn until sunset in her honor. Such honors are not extended to ordinary people. Nohema led an extraordinary life of service. In addition to her nurturing roles at home and at school, Nohema was very active in the Catholic community, attending Mass daily, recited the Rosary every Friday evening with a group of women, a number of whom are here with us at the hearing, and became a liaison between the church and the growing Hispanic community of Fairfield. Nohema helped many find or come back to the church, and when the son of Elizabeth Goitia was diagnosed with a brain tumor 14 years ago, Nohema prayed with her every day. Ms. Goitia's son beat doctors' expectations and ultimately beat his tumor, and he was there in attendance at the prayer and vigil service for Nohema in the high school auditorium. Nohema encouraged others to return to college and finish their education, helped them find scholarships, and pointed out that she herself had earned her degree while in her 50s, so they could too. Willard Chaiden Miller put an end to all that religious and community service too. The difficulties with Willard Chaiden Miller began earlier in the year, after the egging and rock throwing at Nohema's house homecoming weekend, which broke a window. I heard from Paul about this dark-haired kid who sat in or near the front row of her class, his book closed, rarely participating, just sitting there glaring malevolently at Nohema. She tried many ways to reach him, but nothing seemed to work. She'd also met with his parents. Nothing seemed to work. Never before had she had a student she couldn't reach. That student was Willard Chaiden Miller. He planned Nohema's murder over at least 2 weeks, Googled what happens to a student's grade when the professor cannot finish the term, wrote out a plan for the murder, created a checklist of needed murder supplies, and enlisted a Confederate to help him. Paul repeatedly told me, even before we knew any of the facts of the case, that there had to be at least 2 persons involved. Nohema was a fighter. She would not have given up. No single person could have overpowered her alone. Those 2 learned Nohema's daily routines, stalked her, watched her on her daily walks at Chautauqua Park, and in the very afternoon of the murder, Willard Chaiden Miller and his mother met with Nohema at the high school. And there Miller sought Nohema's help in accomplishing his desire to study abroad in a Spanish-speaking country, as his older sister had. Nohema agreed to provide further help he'd previously spurned, and Miller promised to exert extra effort and really try harder in his class. His mother described the meeting as beautiful, full of sweetness, positivity, and promise. All the while, Willard Chaiden Miller knew his promise was false, knew he didn't intend to try harder. Instead, he intended to murder Nohema that very afternoon, and that is exactly what he did. While his Confederate distracted Nohema from the front, Willard Chaiden Miller cowardly snuck up behind Nohema and crushed her skull with a metal baseball bat. Willard Chaiden Miller has shown no remorse. He certainly didn't on the night of the murder. Instead, he went home, did homework, had dinner with the family, just another routine day. He also didn't show remorse on the day of his arrest, not even after his mother reminded him he was being videotaped and recorded, and instructed him, also, we need to express a little more remorse that your teacher is dead. I'm kind of surprised at your reaction. No contrition, no remorse. Again at his plea hearing a year and a half ago. I'm sorry, a year and a half later. He still refused to own up to his full role in this horrific crime. He's refusing to admit that he struck Nohema. And again today, I did not hear any admission from him to what he actually did. Using his own baseball bat, no less. To this day, it's clear to me that he feels no genuine remorse. No doubt he's sorry for himself, sorry he's here, sorry for what's coming, perhaps sorry for his family. But I don't believe he feels genuine remorse for slaughtering Nohema Graber. A student's murder of his teacher over a mere grade should also weigh heavily in favor of a heavy sentence. Society cannot stand such crimes. They must be deterred. You've heard eloquent testimony this afternoon from Lieutenant Kinsella of local teachers and even students fearing for their lives as a result of this crime. Well, it extends beyond this state. I have a daughter who's a university professor in a different state. She recently disclosed to me that this crime has caused her to fear some of her male students who are failing. The impact of this crime on the community and society are factors calling for a maximum sentence. Your Honor, Willard Chaiden Miller deserves every day of a life sentence with no consideration for parole until he has actually served at least 30 years in prison. I discussed this topic with Paul on multiple occasions, back in January and February of this year, and again in April, prior to the plea hearings. On those occasions, Paul repeatedly stressed to me the importance of defendant Miller receiving a sentence of life in prison with no possibility of consideration for parole until he had served at least 30 plus years of that sentence. 35 years was the time Paul thought required, but at a minimum, it had to start with the 3. I had independently landed on 35 years also. Given the utterly cold-blooded depravity of this crime, committed less than 2 hours after meeting face-to-face with her at the school, seeking her help, falsely, when all the time knowing he was about to murder her, calls for the maximum, near the maximum sentence possible. Coupled with Miller's central role as the instigator, planner, and principal actor, cowardly sneaking up behind and striking the critical first blows, a crime that would not have occurred but for Willard Chaiden Miller. The wide ramifications of this crime, Miller's lack of remorse, and his refusal to date to admit his full role. I believe Willard Chaiden Miller should be sentenced to life in prison with the requirement that he actually serve no less than 35 years before becoming eligible to be considered for the possibility of parole.
The next victim impact statement is Barbara Graber, read by Tommy Graber, correct? Her son?
Yep. Dear Judge Showers, Nohema was a warm, selfless, incredible woman who dedicated herself to her community. She was brimming with love and energy that she shared with all around her. Her adoring family, her students, and members of her church and her town's Latino community. I first met Nohema when my brother-in-law Paul brought Nohema to Iowa to meet our family. In 1986, she married Paul, first in a civil ceremony in Chicago where my husband and I hosted a reception, followed by a beautiful church ceremony in Jalapa, Veracruz, Mexico. I've always admired her for how much she has accomplished for herself and her family. She began her career in Mexico City as a flight attendant and then trained to be a pilot for Mexicana Airlines. Shortly after her marriage to my brother-in-law, she made the decision to move to Fairfield, Iowa, and devote herself to raising her 3 children. She loved being a mother. It was her true vocation. But when her family needed her support, her disabled husband and special needs child, she enrolled in college, retrained, and began a career as a Spanish teacher. Nohema found joy in all of her jobs and excelled at each of them. It was a joy to have her as my sister-in-law. I missed so much the long walks we would take in the countryside, and I missed joking with her. I loved telling her my favorite Mexican food was Taco John's. I always got the same response. She laughed and said, "Oh no, Barbara, not to my country." The impact of her death on her family is immeasurable. 8 months prior to her murder, Paul received a new kidney. At last, after years of dialysis, things were looking up for the Graber family. Their prayers had been answered, and Nohema and Paul were planning trips abroad and time to truly enjoy their golden years. Her death put an end to so much promise for the future. I believe Mr. Miller's actions has had a direct impact on the health of my brother-in-law. The all-consuming grief of losing the love of his life led him to ignore early symptoms of an illness that, caught early, could have been easily treated. Sadly, he has now passed away. Nohema's youngest son has significant special and medical needs. Nohema worked tirelessly to meet his needs and to improve his life. She brought the world to him. She took him to church and on international trips to visit family, and she did all she could to enrich his life. I constantly worry about what's next for him and her other children. It's so cruel they will not have their mother when they get married or have their own children. I grew up in Gettinger, a small farming town in northwest Iowa, and left the state following college. Mr. Miller's actions destroyed my idealized childhood memories of rural Iowa being a place where townspeople truly did love and care for their neighbors. Evil didn't live in Iowa. Mr. Miller shattered that illusion. I wish Mr. Miller no harm as he pays his debt to society. It is difficult for me to forgive him because I'm not certain he's truly repentant of his actions. He needs to admit his part in Nohema's murder and not blame others. However, if he takes responsibility and is sincerely repentant, I could find forgiveness. Nohema could conceivably have lived another 30 years. I would have liked to see Mr. Miller live those years behind bars according to the plea agreement between the prosecutor and defense, a life sentence with a minimum of 30 years served before the possibility of parole. I hope Mr. Miller can find ways to improve himself while incarcerated by furthering his education, learning a trade, finding faith, and at a minimum, asking for and receiving God's forgiveness. It would be ironic if he gained fluency in Spanish. Finally, my thanks and gratitude to the following: Jefferson County Attorney Chauncey Moulding and his staff, the Fairfield Police Department, and Jefferson County law enforcement officers, Iowa Assistant Attorney General Scott Brown and his staff, the Iowa Division of Criminal Investigation, the state coroner and staff, victims advocate personnel, Judge Sean Showers and his court officers, Father Nick and the staff and parishioners of St. Mary's Catholic Church, and Nohema's many friends in Fairfield. You guided us through the most difficult time with gentle hands. Thank you.
The next impact statement is Jim Graber, who's a brother-in-law.
As you've heard already, Nohema had a lot of impact on a lot of people. And it only took 2 people to actually remove her from our lives just like that. Everybody loved her. Maybe she was a tough Spanish teacher, but she wanted the best for her students. If you take a class, you should be able to focus. Spanish is usually the easy class in a lot of schools. I can remember that back in my day. But to fathom somebody killing somebody over a grave is just insane. Nohema is one of the kindest, dearest persons I've ever known. I've known her for a long time. She'd go out of her way for anybody. And most of the town of Fairfield can approve to that, attest to that. Because of this event, not only affects the immediate family, it affects the other generations of the family. We have grandkids that are 4, 8, 10, 8, and 4 that live in the Quad Cities with us. And we've had to explain to them what murder is. And my daughter has had to take extra precautions because now she's nervous about it too. She's not comfortable walking in their neighborhoods in case some creep's out there. So it affects a long ways, and like they said earlier, it affects Fairfield a great deal. I agree too. I've listened to the testimony. I've been here to nearly every hearing. And to this date, this is the first time I've ever heard an attempted apology from Mr. Miller. I don't believe it, because he's shown no sign of remorse whatsoever. To me, he's a cold-blooded, premeditated murderer. Nohema had a good life, but she had a lot of good life left. Her death definitely sped up Paul's demise, and it affected their immediate family greatly. I would too definitely recommend, Judge, a minimum sentence of 30 to 35 years and a maximum sentence of life. It's only right. He took a lot of good life out of her and has affected a lot of life out of the rest of us that remain. I would also say that I hope you open your soul to the Lord and maybe ask for forgiveness there first, because you're on a spiral straight to hell. That's it. Oh, one thing. There would be a testimony or a victim statement from my brother Paul. It's his obituary from the funeral yesterday.
The next impact statement is Deanne Graber, who is a sister-in-law. This will be read by Sarah Harms as well.
The statement is from Deanne Graber. My name is Deanne Graber, and Nohema Graber was my sister-in-law, and I am married to her husband's brother, Jim. There are no adequate words to describe fully what this horrific, senseless murder of my sweet sister-in-law has meant, not only to the large Graber family who loved and adored her for countless reasons, but also Nohema's large family in Mexico who cherished their oldest sister and aunt as well, along with extended family from both sides. I am so thankful that neither set of parents were still alive and had to be told of the despicable evil that transcended on their precious daughter on November 2nd of 2021. Hundreds of family members missed her every day, along with thousands of friends. I will never be able to forget the evening Paul called my husband to tell him Nohema was missing. We were at our daughter's for dinner, and I was playing a game with my 8 and 6-year-old grandsons when my husband's cell phone rang. I could tell by the sound of his voice that it was a serious, concerning call and was not going to be good news. When he hung up, he said, "Nohema's missing," in the most shocked voice. My 6-year-old grandson Wesley said, "Gigi, what does missing mean?" This would be the beginning of what would become a devastating loss of innocence for my 2 grandsons, Ethan 8 and Wesley 6. Because not only did I have to explain in detail what it meant for their sweet great aunt to go missing and pray for her safe return, but the very next day we would sadly have to introduce a vile word, murder, to their vocabulary at such a tender age. Definitely one of the hardest emotional conversations of our lives that literally made me sick to my stomach. They had so many questions that we could not begin to answer. No one could at that point, and still can't. And we know it will continue. All we could do was grieve and pray like never before. Just last week, on June 21st, 2023, I was at a park in Bettendorf near my grandson's home. It's one of my favorite things to do with them on our midweek visit. Last Wednesday, on our walk back to the car, Wesley, now 8, saw a bronze marker on a tree near a couple of benches and an overlook of the creek. He stopped to read it and asked why a lady's name was on it. I explained that she had died and her family had planted a tree in the park in her memory. because it had been a favorite place of her when she was alive. He wanted to know how she died. I told him, the plaque doesn't say, but maybe it was a car accident or illness. He immediately said, I know. I asked, how? He made his hands in the shape of a gun and hit himself in the head with it and said, murder. I stopped in stunned silence and knew exactly why he said this. Nearly 20 months after the senseless murder of his great aunt in her favorite park for a walk, and it broke my heart all over again. I gave him a big hug and told him, let's sure hope that isn't what happened to her. Nohema was hands down one of the sweetest souls I knew. She was my favorite family walking buddy, and she could crack me up when she'd ask, do you want to walk on the dirty road instead of just the dirt road near the farm? We'd catch each other up on family and friends we were praying for, and once she told me a story I shared with her gave her chicken bumps instead of goosebumps. She and my daughter loved to knit and crochet together, and she was always excited about any new craft projects happening in the family, and her flan was a Graber family favorite. Nohema was a constant ray of sunshine in all of our lives, and we are all better people for having known and being loved by her. I loved her rock-solid faith and so admired the strength and peace it provided for her in the difficulties of life. She was a mighty prayer warrior and, well, as always, looking on the bright side of every situation. She made everyone feel like you were part of her family, and she had an encouraging, positive word no matter what was going on. I'm sure she was the same incredible pillar of light in all areas of life, be it family, church, work, or community. The loss we have all suffered has been of major significance because of this horrific, evil crime that snuffed out a cherished daughter of the Most High God. I pray her soul fled straight to heaven the very moment her precious head was struck. I had never personally known anyone to be murdered in my 60 years of life, and I will never be able to understand or wrap my head around murder being a legitimate option for bad grades, or how you could ever talk a peer into doing something so heinous to your teacher. It's left me feeling much more cautious and leery going to and from work, running errands, and even taking my grandsons on outings to the parks. What breaks my heart most of all, though, is that you have absolutely robbed her and her 3 children of their precious mother. She will not be there for any more of their life events, especially their weddings and future grandchildren she would have cherished. Yet these same children choose to forgive you immediately, while most of us were still in a stage of shock. Again, this is an enormous testament to who Nohema was and the incredible job she did raising her children. Forgiven people, Christians, are forgiving people, and her children have been the epitome of this. By the grace of God, we will follow their lead because we do not want you to take any more from us than you already have. We will live to honor her memory and love her children in her absence. The one thing that carries me through the toughest days is the hope of heaven and knowing we will be reunited one day in glory, where there will be no more tears, pain, or suffering for anyone who repents and believes in Jesus Christ as Savior and Lord. This would have been a daily heart desire of Nohema, that everyone she knew would come to this life-changing relationships with a personal Savior, including all of her students. To me, a fair sentence would be 50 years, which would have you released at the same age Nohema was when you horrifically took her life. You easily robbed her of several decades she would have enthusiastically relished with her husband and children and future grandchildren. Memories none of them will have the opportunity to make now. The enormity of this loss cannot be measured by her family, friends, and community members. But we will all strive to live our lives in ways that will honor Nohema's devotion and service to all, and for such a beautiful example of a life well lived. The next statement I'm going to read is from John Graber, who is Nohema's brother-in-law. Nohema's absence has created a very adverse effect for not only our family, but the community as well. She was a loving wife and mother for our brother Paul and his family. She assisted Paul with his health concerns and provided well for her family. Since her absence, Paul's health had remarkably declined, with him passing away recently. We as a family believe he'd have lived a longer, more fruitful life if she was still present. Her son Christian has had to make significant work changes as a result, as to help his family. Our family, in addition, has felt a significant loss from her absence, from her loving presence. She was an integral part of our unit. The community has felt a significant loss, and conclusively, many had an adverse effect from her absence, from a noticeable decline in morale and mental health in many. I've noticed this from my present work in the mental health field. She impacted even more residents than we have known, learning so after her death. Thank you for your help in this matter. The next statement I'll be reading is from Alberto Castillo, which is Nohema Graber's brother. It is not about vengeance, like my nephews and niece said. We forgave him. This is about justice, and that is what we expected. When all this started, my feeling about this country's society, where nobody is killing each other, where everybody is killing each other, was a pure rejection. My point of view changed when I talked and spent time with the Fairfield community, the school, and the neighbors. They all made me realize what an amazing person my sister was with the whole community. The way she helped and the way she loved and cared, and how everyone loved and cared for her made me change my point of view again. I realized that the actions of a couple of people do not represent the majority of a community. Personally, I feel a great void, emptiness because of her absence. This absence left me without the chance of spending time with my oldest sister, the sister that took the role of mother when ours passed away. My heart is heavy for my brother-in-law and my nephews and niece. They had taken from them the most important part of their lives. But we have to move on with our lives, and only time will tell how we have moved on. And the last statement I'm going to read is from Socorro, who is Nohema's sister. Your Honor and members of the court, this is not a good situation, nor your position. Even though I don't know you, I pray for you. As a Mexican, you come to this country and try your best. I know my sister did. I know this because when I attended her memorial, I listened to what the community had to say about her, her students, and all the people that knew her. They all gave me the opportunity to know who my sister was. She was devoted to the people around her. She was a kind of person that would spend her time just talking to the elderly, the kind of person who encouraged fellow immigrants that felt lost in this country. Without a doubt, my sister was an incredible human being. I know that she always did her best. I saw it every time I visited her. She completed her master's while she was already married and with children in a country and language that was not hers. My sister loved Mexico and proudly taught Spanish language to her students. In her classes, she would show her students the many different faces that the Mexican cultures have. This way, she would inspire her students to visit Mexico. She was a great neighbor, friend, and sister. She would help the Latin community to not give up and to always try their best. She was loved by anyone who knew her. She was very spiritual and respectful of all other religions. I think that your country has also lost a wonderful human being, a woman who transmitted peace, love, and respect. Dear Judge, I hope you take all the arguments in consideration and come to a just sentence.
Judge, we have one more victim impact statement. That's Christian Graber, who is the son of Nohema.
Hello, everyone. I'd like to thank you all for giving me the moment to speak here. I want to keep this kind of short because I'd like to get home soon, but I want to talk to you directly, Chaiden. I've got no hate in my heart for you, and I've met your mother on several occasions and we had good conversations. She seems like a decent woman, and I'll always treat her with kindness and respect. And I met your grandmother yesterday before the funeral of my father, and we had decent conversations. And I feel sorry for you. And I really feel sorry for your mother, your grandmother, and all your family. They seem like decent people, and I still think that there's potential for you to become a decent person as well. I don't see it at the moment, but I really hope that one day you can be. And I'd be very happy to help you to become a good person.
To 1A, Mr. Miller, I've considered all the sentencing options provided for in Chapters 901, Chapters 902, and 907 of the Iowa Code, and my judgment relative to sentence is based on the 25 factors I'm required to consider for you under the Iowa Code for sentencing juveniles to first-degree murder. Primarily, I'm looking at rehabilitation and protection from the community from further offenses like this by you and others. And in selecting a sentence for you, I've considered your age, and I'll go in depth with that, the contents and the pre-sentence investigation, the plea agreement reached by the parties, and in sentencing you, since you were a juvenile when you committed this crime, the sentencing requires me to conduct a more thorough finding out of sentencing pursuant to Iowa Code 902.122, and I've considered all those circumstances and decided that first you're going to have to be required to submit to a DNA sample. That's required for all felony convictions. I've considered your the brutal nature of this offense, but also in line with the minutes of testimony of the case, along with the entire court file. And I also find that the restitution amount, I'll give the county attorney 30 days to file pecuniary damage statements for all the restitution. That's not the $150,000 restitution that is required in this case. And I will order that you shall pay to the heirs of Nohema Graber $150,000. And that will be to the estate of Nohema Graber or to her heirs, jointly and severally liable with Jeremy Goodale. And I'll order that you're presumed to have the ability to pay Category B restitution, and that you have the opportunity to request determination on that at a later time. Mr. Miller, this is a lengthy record that I'm going to make, but I'm just going to go down the list here and tell you what I have to consider. Not just from this case law, State v. Roby has been talked about, State v. Lyle. I think State v. Majors was the recent one that was discussed by your attorneys. The legislature codified these factors under 902.122. The first factor that I've considered is the impact of the offense on each victim, and the victim impact statements, including the victim impact statement may include comment on the sentence of the defendant, and we have just heard that. But this factor I find to be an aggravating factor in determining your sentence. Your horrific actions led to the death of Nohema Graber, and her family will never be able to fill that void. The victim impact statements remind us all of the pain the family and friends of Nohema Graber will carry with them forever. The second thing I consider is the impact of the offense on the community. I also find this to be an aggravating factor. The entire Fairfield community has been shaken by the senseless, premeditated murder of one of its beloved teachers. I think that came through pretty strongly with Chief Kinsella's her testimony, and that you, along with Mr. Goodale, are accountable for that detrimental impact on the community. The threat to the safety of public and any individuals posed by you, the defendant, I find this also to be an aggravating factor to the extent that any individual who would plan and participate in a murder based on an unsatisfactory grade is an individual that will require immense rehabilitation. And there was some discussion about a mandatory minimum. I am going to issue a mandatory minimum on this case. If I gave the Board of Parole the option to release you without a mandatory minimum, it would be contrary to the public safety of the community you would reside in and to the residents of the community you reside in. There was some discussion about there being an expert to impose a mandatory minimum that most normally would be a matter for expert testimony. This is far from a normal case. And to the extent the mandatory minimum is an issue, I think the facts and circumstances of this case demand it, and I would not be doing my job if I didn't impose some sort of mandatory minimum. The degree of participation in the murder by you is another factor I've considered. It's an aggravating factor. The reason that Nohema Graber was murdered was because you were unhappy with your grade. But for your thoughts, planning, and acts, Nohema Graber would still be alive. Mr. Miller, you and Mr. Goodale committed premeditated murder of your teacher. And it was carried out in one of the most horrific fashions one could imagine, which goes to the nature of the offense, which is an aggravating factor. Planning the murder by stalking Miss Graber, her walking route, bringing supplies such as a wheelbarrow and a baseball bat, that beating the victim lifeless is a horrific act. It calls for swift justice, deterrence, and accountability. With regard to your remorse, you waited to today to show some sort of remorse for the act you and Mr. Goodale committed. I find that you downplayed your role in this homicide based on your admissions and the minutes of testimony and the evidence presented in this sentencing hearing. It's an aggravating factor. State's witness, Talon Sissom Fain, a fellow classmate of yours, who you told that you caught a body with a baseball bat. While the defendant is remorseful for his current situation, there has been little remorse shown by Mr. Miller for Nohema Graber, her family. I think State's Exhibit 131 shows the extent of the premeditation to finalize the win or secure a victory when describing the murder of the defendant that you and the murder that you and the defendant, Jeremy Goodale, committed. Acceptance of responsibility, I actually find to be a mitigating factor. Mr. Miller, I find by you pleading guilty, you spared the victim's family, witnesses in the Fairfield community a protracted trial where the details of this brutal act would be recounted. With regard to the severity of the offense, including the following: the commission of the murder while participating in a felony, the number of victims, the heinous, brutal, cruel manner of the murder, including whether the murder was the result of torture. To the extent the court is to consider there only being one murdered victim as opposed to several, I consider that a microscopic mitigating factor. The overall heinous, cruel, and painful murder is an enormous aggravating factor. Next factor the court has considered and is placing on the record is the capacity of the defendant to appreciate the criminality of his conduct. And I do find this to be a mixed factor. Case law requires me to account for your immature brain while committing this crime. Most of the science I'm familiar with states that a human being's brain isn't fully developed till they're 25. Certainly based on your immaturity, you did not likely think too deeply about what happens to individuals who plan and execute a murder. You knew what you were doing. Whether you appreciated how wrong it was raises an urgent rehabilitation flag for me. Deterrence and rehabilitation require the court to sentence you to a lengthy prison sentence. The next factor I've considered is whether the ability to conform with the defendant's conduct with the requirements of the law was substantially impaired. And again, to the extent that being a 16-year-old high school student impairs your ability to comply with the law, I find this to be an aggravating factor. There's no indication you had any issues prior to November 2021 complying with the law or societal norms. The next factor I consider is the maturity of the defendant, Mr. Miller. It's a mixed bag because it is a mitigating factor that you were 16 when you committed this crime. However, you're also an intelligent young man. Both the Iowa State Supreme Court and both the United States Supreme Court and the Iowa Supreme Court have held that juveniles are constitutionally different than adults for the purposes of sentencing. That's Miller versus Alabama, State versus Sweet. In the State versus Sweet case, it was a 4-3 Iowa Supreme Court case that held that juvenile murderers cannot be sentenced to life without the possibility of parole. The United States Supreme Court held in the Miller case barred life imprisonment without the possibility of parole for all but the rarest of juvenile offenders, those whose crimes reflect permanent incorrigibility. I also cite Montgomery versus Louisiana. I think you're very fortunate, Mr. Miller, that the state of Iowa does not allow the option of life without the possibility of parole, because that would have been a serious consideration for me if I had that option. Next factor I consider is the intellectual and mental capacity of the defendant. And again, it's aggravating. you're an aggravating factor, you're a very bright and intelligent man, you committed an evil crime. The nature and extent of the prior juvenile delinquency or criminal history of the defendant is an X factor the court considers, including the success or failure of previous attempts at rehabilitation. So again, this is a mitigating factor to the extent that you did not have a previous criminal record and you are a good candidate for rehabilitation. However, some of the things reported to by the South Iowa Area Detention Service Agency regarding some warnings and consequences for various infractions of inappropriate comments or unnecessary horseplay or verbally assaulting another juvenile with the threat of violence, these things, arguing with staff, that sort of misbehavior. Certainly some of it can be attributed to your age, but I think it just shows that you're just starting your journey towards rehabilitation. Following factor I considered as well is mental health history of the defendant, Mr. Miller. By all accounts, I don't see there's any mental health issues for you in your record. The next factor the court considers and makes record of the level of compulsion, duress, or influence exerted upon the defendant, but not to such an extent as to constitute a defense. This is an aggravating factor just because it was your plan to kill Nohema Graber, and you recruited Jeremy Goodale based on the evidence and the minutes of testimony. Next factor that the court considers is the likelihood of the commission of further offenses by you, Mr. Miller. In determining what sentence to impose, this factor is difficult to weigh. But with the amount of time that you'll be incarcerated, it is my hope that you will not only have time to reflect on your actions, but to also grow as a person. You're naturally doing it physically right now, but I'm talking about mental maturity. I believe that you're currently a threat to the community based on this planning and executing of the murder with Jeremy Goodale. But with the programming and maturing in the Iowa prison system, beginning with the youthful offender program that was discussed earlier, I believe that you have the ability to avoid committing further offenses because mandatory prison sentences are great deterrents for human beings. The next factor I've considered is the chronological age of the defendant, the features of youth, including immaturity, impetuosity, and failure to appreciate risks and consequences. And this is generally a mitigating factor for you, Mr. Miller. You were a minor when you committed this crime. The law treats you as an adult for the purposes of prosecution, but at sentencing, the law requires me to consider your immaturity, your impetuousness, failure to appreciate risks and consequences in determining the appropriate sentence. You thought, I believe, as all criminals do, but you certainly naively, that you could avoid legal consequences by being coy or pointing fingers at others. Certainly, your failure to appreciate the consequences played a role in your teacher's death. While this particular case also shows that planning that went into the murder, it does also show your impulsivity to reduce a small portion of the mandatory minimum time that I'm going to impose or would otherwise impose on a first-degree murder case. At some point, some of your traits will be difficult to alter, but it is not impossible through rehabilitation. I was troubled when I read that you reported you believe you have a higher IQ than most of the staff at the South Iowa Detention Service Agency. This sort of arrogance is sometimes a reflection of youth, other times it's just your personality. And the arrogance is troubling to me. And I find on the record that arrogance is not primarily due to age, but to an intellectual superiority mindset. The next factor I've considered is family and home environment that surrounded the defendant, which is neither an aggravating nor mitigating factor. Circumstances of the murder of this murder. With regard to the next factor, that's the competencies associated with youth, including but not limited to the defendant's inability to deal with peace officers or the prosecution, or the defendant's incapacity to assist the defendant's attorney in the defense case. I do not find this to be a mitigating factor. You've been zealously represented by experienced and talented attorneys and have been able to present a very thorough defense. Next factor I've considered is the possibility of rehabilitation, and the court finds this mostly to be a mitigating factor. The years that you will spend incarcerated will allow you to learn skills, I guess GED or HiSET and beyond, depending on how far you want to take it, Mr. Miller. Most importantly, reflect on the immense harm you did to Nohema Graber, her family, and the Fairfield, Iowa community. And then there's a last consideration I've been considered as required by the case law and the statute. With any other information that I've considered in my sentence. In recent years, the Iowa Supreme Court has attempted to find an adequate model approach in juvenile sentencing in compliance with Article 1, Section 17 of the Iowa Constitution, ban on cruel and unusual punishment. It's the 8th Amendment in the federal Constitution. I mentioned the State v. Sweet decision earlier that held that life without the possibility of parole for juveniles is unconstitutionally cruel and unusual, according to that 4-3 Iowa Supreme Court case. In the case your attorney cited earlier, State v. Majors, Justice Waterman wrote, "Our earlier opinions have been criticized for running the risk of making it difficult, if not impossible, for a sentencing judge to ever impose any minimum term of incarceration. Yet, as we indicated in Roby, mandatory minimum sentences are permissible, while there is a presumption against minimum terms of incarceration for juvenile offenders. We have expressly held, even commanded, their use if court concludes that sentence is warranted after consideration of the factors." And those factors are what I just went through, Mr. Miller. And based on recent Iowa precedent, I'm not allowed to consider a sentence of life in prison without the possibility of parole, which is permissible in most other jurisdictions. Certainly a high school junior who formulates a plan, or high schooler that formulates a plan with his friend and murders a Spanish teacher is a dangerous person to the community. The definition of malice is the intention or the desire to do evil. And evil does not have a birthday. This court cannot overrule precedent. However, I will not gloss over the fact that you and Mr. Goodale cut Nohema Graber's precious life short. That would not be justice, regardless of your age, Mr. Miller. The bedrock of our criminal justice system is deterrence and rehabilitation. And ultimately, while acknowledging your youth and developing brain, I find that your intent and actions were sinister and evil. Those acts resulted in the intentional loss of human life in a brutal fashion. There's no excuse. There is not a systemic societal problem that explains or justifies your actions. The court finds, based on the nature and circumstances of this offense, along with the required 25 factors that I am to consider in sentencing a juvenile in the state of Iowa for murder in the first degree, that the defendant, Willard Chaiden Miller, should be sentenced to life with the possibility of parole after 35 years. This sentence is permissible under the Iowa law. A 35-year mandatory minimum is not cruel and unusual punishment for the defendant, as it represents the appropriate time of incarceration for the defendant in Mr. Goodale's premeditated murder. It is further ordered that the Iowa Medical and Classification Center in Oakdale, Iowa is designated as a reception center to which the defendant is to be delivered by the sheriff of this county. The defendant is given credit for all time served on this charge, including any juvenile detention center. To the extent that it doesn't apply to the mandatory minimum, Iowa Code Section 90159, Mr. Miller, does allow your term of incarceration to be reduced because of statutory good conduct time, work credits, program credits, and you may be eligible for your parole after your mandatory has been served. You will have that opportunity to see the parole board and have good time credit at that time. You have the right to appeal your guilty plea, but your attorney must file a written notice of the appeal within 30 days. And we talked about waiving that right at the guilty plea sentencing. If you do want to attempt to challenge your guilty plea, there is an application for permission under Iowa Code Section 81429. The appellate court is determined whether the application is granted or denied or preserved for post-conviction relief. Regarding your sentence, if you're only appealing your sentence, your attorneys must file a notice to the Iowa Supreme Court within 30 days, serve the written notice of the taking of that appeal upon the Jefferson County attorney, and file the same with the clerk of court, together with evidence of that service upon the county attorney, and you must mail or deliver a copy to the Iowa Attorney General's office. The service and the filing of the written notice of appeal and the time and manner just specified as jurisdictional, and a failure to comply with such requirements shall be deemed a voluntary waiver of your right to appeal. You may be entitled to court-appointed counsel to represent you on your appeal and the preparation of these proceedings at state expense. Judgment accordingly, minimus accordingly, and immediately, no bond on appeal. Counsel, for the record, we need to make at this sentencing hearing. From the state.
Just one thing, Judge. I know he will go to the youthful offender unit, I believe, at Oakdale. I don't know if your order needs to specify that specifically or not. I just thought of that a minute ago, so just to put that on your radar, but otherwise, nothing else.
My understanding is they'll automatically send him there when he gets there. Any further record from the defense?
No, Your Honor.
That completes the hearing.